Welcome to Dolly Talk. How is everybody doing? Oh, we have a new trial today of Sherrick Vaughn. Yes, Babu is very excited, aren't you? Um we if you remember we saw him a month or so ago ish. He's out of Tennessee in Judge Wolf's court, and he was pro se. Eccentric is a one way to describe it. Yes, Babu. But hey, Maddie, how you doing? Hey, Louise. Yes, I will. Got that taken care of. Paul, how are you doing? Brad and Mads is here. Um, Great to see Sal has found a new trial, or maybe his wonderful mods did. Yeah, they mostly them. Am I sick? I don't think so. Just I guess I do sound it. I think I messed up my voice yesterday doing a dramatic reading, and I haven't done that in a while. I sound nasally? Oh, thank you. I'll try not to be offended. um, I did kind of move my microphone. Maybe that's why. I don't know. Oh well. I Hey Dreambert found the Vaughn trial today. It starts, I think, outside the presence of the jury. I was gonna skip that, but since we're watching it for um to see how he does representing himself, I think it's good to see how he does when he's arguing motions and things like that. Hi, Hella. Dolly wants to talk about Lauren. Always. All right, guys. Jesus. All right, so there's our strapping young man in the black suit and red tie, his power tie.
Well, that does not apply in this case.
Yeah. The one you're looking for, I think, is styled motion to quash / dismiss with prejudice.
And what motion to quash?
/ dismiss with prejudice. It was filed that July 7th. And I've got 3 pages, but I think online has more pages.
All right, I found it.
There may actually be. Okay.
The motion to quash, dismiss with prejudice, or suppression was in 336. So the only motion that I see relating to this case is the one that you just referred to, filed July the 7th.
Hey, Tracy.
Motion to quash / dismiss with prejudice. Madam Clerk, would you please have, Kenny, can you run a photocopy? Do you have a copy of this motion, General Bryson? You run a copy of that for Mr. Vaughn, please. May I see the motions that he filed this morning?
Come on.
Make two, one for Mr. Vaughn and one for Ms. Bryson.
Come on, speed it up, guys.
Dismiss with prejudice.
Rearrange some things because some of the witnesses that I wasn't going to call at trial are relevant to this motion. So if I could have just a moment, please.
Just don't answer her, Judge. It's a silly woman lawyer. You don't need to respond to her. Really? You're really not going to say anything?
May I make another request to brief my witness, please?
There is no statutory right for you to brief a witness. If the witness is available and you can talk with them, that's fine. But being as the fact that you're in custody, we have certain procedural safeguards that have to be followed. Depending on whether or not we proceed with the trial today, I will determine whether or not you have an opportunity to speak to her.
Shouldn't I be given the same privileges as lawyers?
You will be given the same privileges as a lawyer. And you've had that same privilege to communicate with this witness while you were in custody.
In custody through a monitored telephone conversation and chirps?
Yep.
That's not the privilege I'm required, Your Honor.
You are entitled to the same privileges in court as an attorney would have, but there are certain limitations on that. Because of the fact that you're in custody, you obviously have to be accorded the rights that an attorney would have with those limitations. So
Where are you getting these rules at, Your Honor? Because I would like to read them myself.
we're gonna deal with this motion right now, and then we'll determine whether or not you have any other option regarding speaking with this witness. So you have a motion to
Where are you getting that
quash / dismiss. Is the state ready on this motion?
Yes, Judge.
All right.
State
Mr. Vaughn's, it is Mr. Vaughn's motion, and it is a motion to quash or dismiss with prejudice. So are we treating this as a suppression motion?
Yes, Your Honor. I filed this when I was asleep one night. We can treat this as a suppression.
I think reading through the motion, the appropriate legal styling would be a motion to
All right.
suppress.
Then the state may proceed.
State would call Officer Jeffrey Clark.
So we're going to have to call some witnesses
Step
before the
around,
trial.
please. Hold.
Thank God have mercy on their soul.
Are you Officer Jeffrey Clark?
Yes, ma'am.
Do you go by Jeffrey?
I go by Scott.
Okay. But your report says Jeffrey, so Officer Scott Clark. And are you an officer or do I need to use a different title?
Recently promoted to corporal.
Corporal.
Oh, well, corporal.
All right. Corporal Clark,
Recently promoted
you
corporal
arrested
Clark.
the defendant on August the 30th of 2022. Is that right?
Yes, ma'am.
Explain to the court where everything happened and what was going on when you arrived.
It occurred at the Exxon gas station at the intersection of Skyline Drive and Highway 46 that adjoins the Crystal's fast food restaurant. The call that we received was a priority 1 dispatch for a disorderly male within the store.
Okay. And when you arrive, had other law enforcement arrived on scene before you?
Correct.
And who was there before you?
At the time, Agent Brad Garland and Agent Ronald Tilley. with
They
the
aren't even
23rd
corporals.
Judicial Drug Task Force.
And
Ronald Tilley. I think so. I believe that's his first name.
Tilley. And had Agents Garland and Tilley already placed the defendant in handcuffs?
Not until I got on scene.
Explain to us where the defendant was when you arrived and what was going on.
When I arrived, they had already moved over to the Advanced Auto Parts parking lot in a Cadillac Escalade.
When you say they, who do you mean?
Mr. Vaughn and Jennifer Dozier.
Okay. And they were in an Escalade. Were they inside the vehicle or outside the vehicle?
I cannot recall.
Okay.
So you're going to have to speak up. Pull that microphone more. There you go. Speak
There
into
we
the
go.
microphone.
Is that better?
What was the answer? Where were they?
I do not recall if they were in the vehicle or outside the vehicle upon my arrival.
And let's go ahead and cross this bridge. You were wearing a body cam at this time.
Yes, ma'am.
When you filled out your grand jury packet, you requested that the body cam be downloaded and provided to the DA's office.
Yes, ma'am.
And we never got that.
I know the DVD request was submitted. I do not know from my memory from there what happened.
Now, around that time, the agency was also having some problems with the video system.
Yes, ma'am.
Well, this is Tennessee. I'd expect it to have VHS, so DVD is pretty high tech for them.
Files were getting corrupted and the video files were messing up.
Objection,
So-
Honor. She's leading.
Trying to remember what that actual question was. I will rephrase and continue. And did anyone intentionally delete this video?
No,
So we are left with what options on why we don't have a body cam?
I'm not sure how to answer that.
Could it have been human error
Possibly, yes.
or problems with the system?
Possibly, yes.
All right, going back to arriving on scene, the parties, the defendant was at the Advanced Auto Parts. Where were the task force agents?
They were there with them.
In the parking lot of Advanced Auto Parts?
Yes, ma'am.
Okay. You said Mr. Vaughn was cuffed after you arrived?
Yes, ma'am. After I arrived, I believe Mr. Vaughn was very hesitant to identify himself at the time after I arrived, and he had the odor of alcoholic beverage coming off his breath in person, and that's when Agent Garland detained him.
What was his behavior like at that point?
I would say irate.
Aw.
Was he still causing a public disturbance?
Not as much, but being hesitant to cooperate.
And I tried to tell him I was a corporal, and he wouldn't listen to
Did
me.
you question Mr. Vaughn?
I asked him what had occurred at the gas station.
Was that before or after he was in handcuffs?
I believe before.
And did he give you any variation of the events at that point?
He stated to me that they had a disagreement with the female inside the gas station, and that he had held the doors shut afterwards for an unknown reason, preventing the clerk from coming out. I know I have in my report, and I believe it was said on scene, that the female inside the store had issues with Miss Dozier.
Was there a search of the Escalade?
There was.
Why was there a search of the Escalade?
Agent Tilley deployed his K-9, and I believe it alerted on the vehicle, and there was a search, probable cause search conducted from there.
Aw, narc
Was any
dog.
contraband located in the car?
No, ma'am.
Was anything pertinent to this case located in the car?
There was an ID with Mr. Vaughn's name on it that was used to identify him, where he was hesitant to identify himself.
Great going.
Did you ultimately decide to arrest the defendant?
Yes, ma'am.
Why did you arrest him instead of cite and release?
With the number of charges that I had at the time, I felt it was more pertinent to make an arrest.
Would you normally cite and release someone for an assault?
No.
Would you normally cite and release someone for a false imprisonment?
No,
Would you normally cite and release someone for a public intox?
no, Your Honor. No, ma'am.
You said you smelled alcohol on him. Was there anything else in his behavior or demeanor that indicated his level of intoxication?
I'm not sure.
But you didn't do like field sobriety tests or
No, ma'am.
anything?
He pinched my ass and called me cute. Does that count? Oh, do we get a? Oh,
All
well,
right, Judge, I will pass the witness.
Vaughn, you may cross-examine.
Officer Clark, is it?
Yes, sir.
How you doing today?
I'm doing good. How about you?
I'm doing all right. This case that we're here for on today, do you recall the date of that case?
right now we are doing. Excuse me. God, my voice is all messed up today. Welcome, cats people. Hope you're doing well. Thank you for the redirect, Cat. We are covering a pro se trial in Tennessee. Again, he had a trial about a month ago and is back again for some more charges that he has, insisting on representing himself. Right now, we are doing a hearing before the trial with some witnesses to decide if they're going to rule on a motion to dismiss, I believe.
I believe August 30th of 2022.
2022. So, did you read any reports today, or is your memory just that good?
Press.
I'm just referring to my report.
Referring for a report. Okay. So, just from the report, that's what we're going to base all these questions off of. You answer them from your report, basically.
Pretty much, yes.
Okay. At the time of this incident that we're referring to, was you present at any of it? Did you see any of it?
No, I did not.
You didn't see any of it. When you arrived at the scene, what was you a witness to?
Testimonies from the victim and talking to you.
What about any other testimonies from Jennifer or the other officers present?
Jennifer was hesitant to say much of what happened.
Okay, what about the other officers?
They just gave me the down low of because I was not far behind them.
Oh, the download.
So you didn't get
respond.
firsthand knowledge of any of this?
I believe, honestly can't answer to most of that, but I know I was not far behind the agents when I was responding to the call. And they might have told me something, but off the top of my head, I cannot recall.
Okay, so you just have trouble remembering, correct?
It was 3 years ago, so yeah.
Okay, so the time barrier made it troublesome for you to remember what happened?
Sorry.
The time barrier making it troublesome for you to remember?
Yes, sir.
Okay. When you arrived at the scene, you said that we were at the auto parts store.
Correct.
Can you recall where me and Miss Jennifer were?
Off the top of my head, I cannot.
How many officers do you recall that was at the scene when you arrived?
When I arrived, it was 2 drug task force agents
Okay.
and myself once I got there.
Let me see here. You said that when you arrived that there was a search, correct?
Later on, yes,
Was you present for this search?
I was.
So you was? Was there a dog at the scene?
There was.
There was. And you said you had a body cam present?
Yes, sir.
Did anybody else have a body cam?
I cannot answer for the drug task force agents because they have their own agency and director and everything. So I can't answer for them. I know when I was present, I had a camera and it was on, yes.
Okay, what about your patrol cam? Was that on too?
Should have been, yes.
And you don't have either of those?
I do not. That was a different recording database. brand or
Judge's
whatever you wanna
vodka
call
in
it.
there.
So when you get these recordings, do you submit them?
When we had that software system, those cameras were downloaded daily by plugging them up. The dash cam and car cameras were recorded with an SD card inside the camera, And every pay period, those cards were given to the shift sergeant to be downloaded into the software.
And what happened to them between that time and getting to the courts?
They would be in the software, and then around the time of the grand jury packet, I put a DVD request in for it,
So there was an error somewhere, the reason it didn't make it to the courts?
possibly.
Okay. Could there have been any errors committed that night that you arrested?
Are you asking technological wise, or?
Yes.
Very well could be.
Okay. So when we come to cite and release, is that a mandatory or officer's discretion? Is that what
It's
you're talking?
discretion.
It's discretion.
Correct.
Okay. Did you give, you said that you smelled alcohol.
Correct.
Did you give any breathalyzer test?
No.
Did you give any field sobriety test?
No.
Did you have any blood drawn?
No.
Could it have
And you
been
wasn't
your
present
breath?
for any disturbance at the Exxon, correct?
No.
So you arrested me without a warrant?
You were placed in my custody, and a warrant was drafted and then presented to a magistrate.
At the police station?
Correct.
At the police?
So I was arrested, correct?
Correct.
Okay. Without a warrant?
That's how it usually is. A warrant's drafted. You're placed in my custody, a warrant's drafted, and then presented to a magistrate.
Okay. And you stated there was nothing found for, during the search of the vehicle?
Negative.
But they said a dog did hit on something, so that would be a false positive, or?
Did a dog hit
I
on
cannot
someone?
answer to how the workings of a canine are because I'm not certified in that. That would have to
I'm
be
not a
for an officer
dog.
that has that certification.
Okay. Did you see this dog with your own eyes?
I did.
Okay.
Did it have four
So you don't
paws?
recall me being in handcuffs and sitting on the sidewalk when you arrived,
I cannot recall off the top of my head, no.
and then being transported over you and y'all switching handcuffs?
We would have swapped handcuffs at some point, yes, because
Okay.
I do recall Agent Garland detaining you, but I do not recall what you're asking. But I will say, that way I'm not taking that agent's handcuffs, I would have done a cuff swap on you, yes.
Okay. And when I was placed in handcuffs, was I placed in the back of the police car?
You would have been placed in the back of mine.
Okay. And then the investigation continued?
I cannot recall, but more than likely, I probably went and talked to the victim at the gas station.
Okay. Why didn't you get any statements that night?
It would have been the recorded statement of the victim and then what she told me.
You didn't think she needed to reduce that to writing?
Didn't think I needed to, no.
Also, I seen in your report that you witnessed you witnessed the store camera of some hands up in the air.
Like,
She
just
showed me a
don't
still
care.
shot from the cameras that she took on her phone. I
Did you
believe
get
her
a
phone.
Did you get a copy of that?
I did not.
You didn't think that was reasonable for your investigation to get a copy of that?
It was just my eyes and my testimony.
Judge, we're going into general cross. This has no relevance to the motion.
It has relevance to proving that
Reverend?
there was improper procedure, Your Honor, that you put that in your warrant, that you had video camera, then why didn't you get a copy of it?
Judge, if we could have a ruling on the motion.
Motion is sustained. Your objection is sustained.
Okay. Let me see. Other questions I got for you. Did you get a statement from Jennifer that night?
Did not.
When you were viewing this camera, was there any other witnesses there?
I believe there was people inside the store, but they were not identified and they did not stick around.
Did you think you need to get their witness statement?
And that's up to them if they wanted to stay. I can't forcefully hold them there as a witness. If
Did
they
you
don't wanna
question any
comply.
other witnesses?
I did not.
Okay, thank you, Your Honor.
Redirect by the state.
What did Bethany Page tell you happened inside the store?
Bethany advised to me that Mr. Vaughn was a daily customer and he normally came in there to buy a dip. She advised to me that Mr. Vaughn was irate with her on this day and accused her of being a CI or criminal informant for drug task force and had threatened to beat her up in the store.
Did that cause her to fear that he would actually beat her up?
Yes.
Did other customers come into the store during the time that Mr. Vaughn was saying these things?
I believe Bethany told me there was other customers in there attempting to buy items. Yes.
Nothing further, Judge.
Vaughn?
You said Miss Bethany stated that I threatened her, correct?
Yes.
Word for word. Can you recall what she said?
Not word for word.
Did you inform Miss Bethany her right to get a restraining order?
I did not know.
You didn't. You didn't think someone that was threatened, their life in danger, should be informed that they need a restraining order?
Again, this is outside the scope of the suppression.
Sustained. It has no relevance to
Okay.
the question of whether this motion should be granted.
All right. Thank you, Your Honor. That's all I have.
Thank you, sir.
Anything further from this witness? Sustained. I'm sorry. Counsel, you may step down. Oh, your next witness.
Judge, may I see if my other witness has arrived?
You may.
It would call agent.
Are you Agent Ronald Tilley with the Drug Task Force?
I was
You were. You are now, what is your rank with the police department?
detective.
Oh. Fancy.
Detective Tilley, I will do my best to refer to you as detective, but you have been agent to me for a very long time.
You can just call him Dick.
Now, let's go ahead and clarify. You do not independently remember much about the day when you came out and Mr. Vaughn was at the Exxon.
That's correct.
You've reviewed this report
Yes.
and still have no independent memory.
No.
So what I'd like to talk to you about and to explain to the court is at this time, you were a canine handler, is that right?
Yes.
Okay. Your dog's name was Nina.
Yes.
What certifications did Nina have?
She was certified through the USPCA as a detection dog, odor detection dog.
Okay. What odors was she certified on?
Marijuana, cocaine, heroin, and
Kept sniffing my crotch a lot.
that's
Monkeypox.
And I'd like to talk about, and you two were certified together as handler and dog,
yes.
and you would have had an up-to-date certification at that time.
Yes.
So when Nina or any canine who's certified alerts on a vehicle, does that necessarily mean you're going to find drugs in the vehicle?
No.
Could you explain that?
Yes. So the dogs are trained on the odor of narcotics. So when they detect the odor of a narcotic or drug, they give an alert, a passive alert, such as a sit. And on that alert gives us probable cause to believe that there's narcotics inside the vehicle or box or whatever container type is there. And that's just based off of the odor.
And if a dog is alerting and you're not finding drugs, what does that tell you?
It tells me that drugs have been in the vehicle, whether they were, in a case of marijuana, smoked in the vehicle, or somebody carried them into the vehicle and have left the vehicle with the drugs. The odor still stays around.
And again, do you remember anything about your interactions with the defendant or anyone else that evening?
I do not.
Nothing further, Judge.
So don't give Hunter Biden a.
Vaughn, you have any
Right.
questions for this witness?
Detective Tilley, how you doing today?
Doing good, sir. How are you?
All right. You remember me?
I do.
You do, from the night of the arrest?
Previous interactions, I do not remember this particular night.
I don't think I remember you from any other. I couldn't pick you out in the lineup.
Really?
Yeah, okay. So I know you're having a hard time remembering a lot of this stuff. It's so long ago. You're just based on reports, but I got a few questions for you. When you got the call on your radio, you showed up to this scene. Why did you, as drug task force, show up to this scene?
I believe, I don't remember if I showed up to the call or if I was requested out, but I believe we were just close to the area, so we responded.
Is it normal to intervene with normal misdemeanor calls like that?
Yes, if we're in the area of a call for service, whether it be a misdemeanor, felony, it doesn't matter what the call is. If we're close to it, we'll respond.
Okay. When you arrived, do you recall where you found me at?
I do not.
Maybe auto parts store or Exxon?
David, this part is not in front of the jury, but like an hour or so, he will be testifying, and I do believe the jury will be there. But right now, no. This is just a motion to suppress hearing.
The report stated advanced auto.
Okay. Do you recall where I was when you arrived?
I do not, no.
You don't. All right, let's ask some dog questions. Does dogs hit for alcohol?
No, mine doesn't.
Yours does?
No.
Oh, that's good to know. Do you recall, and how about this? Let's just do this instead of me.
Yeah, let's not make a joke about how you can avoid detection about your alcoholism by the police in the future, sir. Just saying.
Asking you these questions and you don't know. Do you recall anything from that night?
I do not, no.
This is, yeah. Give me a lawyer, dog.
I just don't see the point in this. You can't remember nothing.
Yeah, all of us.
Your Honor, that's all the questions I have for him.
Thank you. Any redirect by the state?
I don't see the point of it either.
The task force office, how far is that from that Exxon?
I don't know, a mile and a half, 2 miles.
So, and my understanding of the questions that Mr. Vaughn asked, even though you're a task force agent, you're a law enforcement officer, correct?
Yes,
So when a call comes out and a task force agent is the closest, even if it's not a drug call, are they going to respond,
yes,
especially for a priority one?
yes.
Nothing further, Judge.
Vaughn, any other questions?
Yes. So you and your partner, I can't recall his name. Well, y'all would be the first ones on the scene, correct?
I believe that's what's stated in the report.
Okay. Did you make a report?
No,
Why not?
I did not seek any charges in this case. The city showed up and took over the situation.
Would you be a witness?
Yes.
I mean, you first responder, wouldn't you don't think that was necessary?
We don't usually do reports when we're not the primary officer.
You don't do reports, but you think it's okay to show up to scenes? I mean, it seems like you're doing half the job there, sir.
No, the primary officer does the report for just about all calls. Every now and then there will be a supplemental report done for a main report, but usually the primary officer does the report for calls.
Since you brought that up, the primary officer, he wasn't present at the scene when you arrived, was he?
I can't recall if he was or not. I don't believe it was by reading the report.
Okay. So he had to receive all his information from you and your partner, correct?
I guess so.
Well,
Okay,
let's
thank you.
specify what you mean by partner, sir.
Anything further? Thank you. Detective, you may step down and you are released.
Thank you, Judge.
State may call this next witness. All right. Mr. Vaughn, the state has rested their proof. Do you wish to have any proof offered on your own?
Yes, Your Honor. I would like to call Jennifer Dozier.
Jennifer Dozier,
Yes, Your Honor.
Hey, Kat, how are you? So,
please, and ask you to raise. Mr. Vaughn, you may ask.
wait, what the hell did she just do?
Mr. Vaughn, you may ask.
Great going.
Good morning.
Good morning.
You know what case we are here for today?
Exxon, I believe, is what I was told.
Okay, that's just the Exxon case. Was you present at this?
I was in the car.
Okay, you was in the car. Do you recall my state of mind that night?
What?
I mean, we had just left work. That's all I recall.
Okay.
We had just left from Sam's.
Um,
From Sam's, it was our boss.
see how this gonna work. All right, when the police officers arrived at the scene, where were we at?
We were in Advanced Auto Parts getting a part for Sam's Derby car.
Okay. And what brought our attention to the parking lot?
The police by the vehicle.
What were they doing at the vehicle?
I don't recall.
Okay.
She reminds me of my ex, Jennifer.
Do you recall the doors being open on the vehicle?
I believe at one point they did because they said it was involved with the situation down the road.
Did you see any dogs at the scene
Later,
later on?
Yeah.
Did you see dogs present when?
not initially, no.
Okay, okay. When we exit Exxon, at the Advanced Auto Parts store,
Jennifer's are all the same.
how did the officers address us?
They just approached us and asked what was going on, made us sit on the concrete and figure out.
Maddie, I wonder if she's a liar. Well, her name is Jennifer, so I think it's safe to assume she's a liar.
What was going on.
Were we placed in handcuffs?
I wasn't. I'm not aware if he was or not. I'm gonna be honest. It's been years.
Okay. Was I irate at any time during this night?
Only when you beat me.
Not to my knowledge, but
Okay. Let's go back over to the Exxon. Was there any police present at the Exxon?
no.
Was there a lot of people present, if you can recall?
It didn't look very packed from what I recall. There wasn't many cars there.
Did you see me threaten anybody?
No,
Did you hear me threaten anybody?
no.
Did you see me cause any incident with anybody at the Exxon?
I didn't see you cause an incident. You know, I heard that, you got into an argument or whatever.
Then
Held the
you're
door
gonna
for a
have to
second.
Speak up a little
Sorry.
bit, please.
I heard that you had gotten into an argument with her and then you kind of like held the door a little bit
Did you see me hold the door?
for like a split second, yes.
Why would I hold the door?
I'm a gentleman.
She was trying to get outside, apparently.
What was her actions, the reason I held the door?
Supposedly she wanted to fight me, but I don't even know her.
Okay, where was she at previously before?
Behind the counter,
How did she get to the door?
assuming she walked around. I didn't see that part. I just looked up and seen you both at the door, and then y'all come out. Both of you come out,
What was she doing at the door?
yelling.
Was she
And just yelling.
scared?
I can't tell you. I don't know how she reacts when she's scared.
I mean, was she yelling she was scared or angry or?
I mean, she sounded angry to my knowledge, but I don't know. Some people react and get angry when they're scared.
Okay,
You know, I do.
okay. Um, and you don't recall, wait, you said you do recall all that. Did you write a witness statement that night?
No, not to my knowledge, I did not.
Why didn't you?
They didn't ask for one.
Okay. All right, thank you. One more question, Your Honor.
General Bryson, you have questions? Thank you, ma'am. You may step down. You are not free to leave because we have a trial coming up. So you'll step out in the hallway and just remain outside. Mr. Vaughn, you may call your next witness.
Oh, that'd be my last one, Your Honor.
All right. State, have any rebuttal proof on the motion? Mr. Vaughn, I will hear you an argument about your motion.
Oh, I'm sure this is going to be some riveting argument.
For first, Your Honor, it seems like nobody can recall the entire incident, my witness nor the states. The distance of 3 years is making this difficult for anybody other than reading a report, which my witness was not given that opportunity nor briefed.
It was 3 years ago.
There is no
Not
body
guilty.
cam footage to prove anything that none of the officers saying. Bethany Page herself is not here to make a statement, nor does she have a written statement or a video recorded statement to justify what the officers saying other than each other. There is no proof that any of this has happened, Your Honor. That they followed procedures like they were supposed to. There was supposed to be a warrant before I was arrested. There's no proof that I was drunk.
Sure.
This is a Fourth Amendment violation, Your Honor. Illegal search and seizure. There is no proof that they had any reason to open the truck doors. It just shows malicious intent of the officers, Your Honor, and I believe it'd be in the court's best decision to just dismiss this case. And then it's just in violation of statute 47-103 in grounds of arrest of an officer without a warrant. An officer without a warrant arrest a person for a public offense committed in their presence. None of this was even committed in their presence, Your Honor. The arresting officer is coming on hearsay knowledge. The DTF officer showed up, and I'm already at Advanced Auto Parts. I'm not even at Exxon.
Wait, the officer is
there was
DTF?
there was no ongoing crime. That's all I have to say, Your Honor.
General Bryson?
Judge, first I'd like to let the court know that Ms. Page is present. She will be testifying at trial. Because a suppression motion is a preliminary question under the rules of evidence, because we are determining the admissibility of evidence, the state may put on hearsay evidence, and that's what the state elected to do under Rule 104, preliminary questions A, questions of admissibility generally. So Ms. Page is here and present. So Judge, first of all, I'm a little bit confused what the defendant is trying to suppress. So you have his statements, which were made after he was asked to take a seat. He did make a statement admitting that he had held the door closed on the witness.
Objection, I didn't, Your Honor.
On scene, Judge, not today.
I would overrule the objection that this is argument rather than testimony by the district attorney, but I would point out that during representing yourself, and you asked Ms. Dozier the questions, and when she responded to say that, yes, you had gotten into an argument, you repeated her answers. So technically, the state is able to argue that you have made that statement. So,
I'm not here to make a testimony, Your Honor. I'm here to defend myself. I was not put under oath.
I understand that.
And Judge, the officers testified, Corporal Clark testified that the defendant told him that he held the door shut.
The objection's overruled.
Yes, Judge. So There was a dog alert on the car. The only thing obtained from the car, which could be argued subject to suppression, is the defendant's identification, which we're not entering into evidence, which would arguably be subject to inevitable discovery. So the only things I can see he's arguing to suppress are his own statements or his identifying documents. So the state is ready to proceed. In regards to the citation in lieu of arrest, the officers observed a continuing offense in their presence, which is public intoxication. And public intoxication, disorderly conduct, those are not offenses that the option to cite in lieu of arrest is available under 40-7-118, which is use of citations in lieu of continued custody or arrest. And if there is a danger of an assault continuing to occur, that is not eligible for citation in lieu of arrest. So, Judge, for the foregoing reasons, whatever he is saying should be suppressed, should not be suppressed, and this case should go to trial.
Anything else, Mr. Vaughn?
Yes, sir, Your Honor. Since the state's confused at what I'm trying to suppress here, Your Honor, let me inform the state that it is illegal against the Tennessee State Constitution and the Fourth Amendment of the United States to arrest someone without probable cause. To detain someone without having any evidence whatsoever, and clearly they still don't have the evidence here to produce today. No body cam footage, no witnesses that can testify that didn't make a statement that the state didn't help them come up with their own testimony here today, Your Honor. Continuing offense, everybody testified. I was at AutoZone when they showed up. So
At
there's
Olive
no
Garden?
continuing offense for the alcohol, Your Honor. There is no breathalyzer. There is no field sobriety test. There's no blood drawn. There's no proof that I was even drunk, Your Honor. The state can't even prove that. And to place somebody into custody and investigation, I don't even have all the cases here today, Your Honor, but one of them will be brutal. You can't put somebody in the back of a police car and investigate something. It's illegal. And I was placed in handcuffs and held for a while, Your Honor. Illegal arrest is illegal arrest, Your Honor. I don't care how you look at it. That's all I have for you.
All right, this is a motion to quash or dismiss with prejudice, and the grounds that have been raised has been that it was an illegal seizure under the Fourth Amendment because of the fact that the defendant argues that there is no probable cause for the arrest. The proof that has been offered at this hearing was that law enforcement responded to a report of a disturbance at the Exxon station, which also is involving, I think that's where there's a restaurant there. And as a result of that, when they arrived, the defendant had been moved, or at least when the Officer Clark arrived, the defendant had been moved over to the Advance Auto parking lot. But during the continuing investigation of what occurred, the proof has been, according to the state's proof, that the defendant was irate, that the defendant had a smell of alcohol about him, and that there was a report of there having been an assault and basically a false imprisonment by the holding of the door. The proof also established that the defendant, according to the officer's testimony, admitted that he had held the door, and by the defendant's own witness, it was established that he had gotten into an argument with the clerk in the Exxon station, and that when she attempted to apparently exit the store, that he held the door against her. So the court finds that there was, in fact, probable cause that a crime had been committed at the time the officers took the defendant into custody, and that their response was appropriate, and therefore it was not a violation of the Fourth Amendment because it was a continuing situation that simply had transferred from the Exxon station to the Advance Auto Parts. So therefore, the motion to quash or dismiss is denied in the case, we'll proceed to trial. We have other motions that the defendant has filed this morning. In general, I don't think you have had an opportunity to actually read.
All right, let's just skip to the trial now. There's not much left here. So yeah, see what we get through.
Prior to the finding of this indictment, in the county and state aforesaid, Sherrick Marquis Vaughn, then and there, in a public place with intent to cause public annoyance or alarm, did unlawfully cause a disturbance by Sherrick Marquis Vaughn, being loud and disruptive and engaged in fighting or in violent or threatening behavior, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose, or made unreasonable noise which prevented others from carrying on lawful activities, in violation of Tennessee Code Annotated 39-17-305, all of which is against the peace and dignity of the state of Tennessee. Count 4, and the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about August 30th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sherrick Marquis Vaughn, then and there, did unlawfully appear in a public place under the influence of a controlled substance or any other intoxicating substance to the degree that the offender may be endangered, there is endangerment to other persons or property, or the offender unreasonably annoys people in the vicinity, in violation of Tennessee Code Annotated 39-17-310, all of which is against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
To that indictment, how do you plead, Mr. Vaughn? Plea of not guilty is entered. All right, ladies and gentlemen, the next step would be for the state and the defense, if they choose, to make an opening statement. Do you wish to make an opening statement, General? All right.
At the time that this case happened, Bethany Page was the clerk at the Exxon there across from Walmart, but in front of the post office. And the defendant had been a customer at times before, come in and out of the store. She had seen him. But on this particular day, he came in, and she will tell you that she smelled alcohol on him, and that from the very beginning of him entering the store, he was yelling, he was loud, he was accusing her, using a different name not hers, of being an informant for the Drug Task Force. They argued back and forth some. Other customers came in the store. Mr. Vaughn left, and he held the doors, preventing her from coming out. That will be the proof that you will hear substantially for all of these counts. You'll also hear from the officers that came about Mr. Vaughn's behavior when they arrived, and anyone else that was there. You will hear that the defendant's girlfriend was present, but officers and Ms. Page will tell you that she did not go into the store. She was in the car during this interaction. And so your primary proof will be the testimony that you hear from Bethany Page about what happened to her on this day. And at the end of this, state will come back to you and ask you to return a verdict. Thank you.
Mr. Vaughn, do you wish to make an opening statement?
Good evening, y'all. I'm sorry, I'm not 100%. I got a headache, y'all. I see stars all the way around, y'all. Please forgive me that I'm not more invested in this, I guess, when it's been all about me. What the state has said, basically I can say that you're going to hear a lot of hearsay evidence, no one with firsthand knowledge. You're going to hear basically a lot of he said, she said with nothing to back it. And I'm here to prepare and show you that today. Thank you.
All right, state may call your first witness.
State calls Bethany Page.
Bethany Page. Right hand be please.
You, Bethany Page.
Yes, ma'am, I am.
All right, I'm gonna ask you, you gotta pull that microphone up and speak into it. You're a pretty loud talker, but these people have to hear everything that you say, okay?
Yes, ma'am.
Okay. Would you spell your first name and your last name for our court reporter?
First name is Bethany. Bethany, last name is Page, Page.
And in August of 2022, where were you working?
Exxon,
Now, there are a couple Exxons in Dixon.
the
Can
one
you-
that is connected to Crystals.
Okay. And that is in Dixon County.
Yes, ma'am.
And we're talking about the one, I think law enforcement calls it Malfunction Junction.
Pretty much, yes.
Okay. So Walmart is kind of across from you, the post office behind you.
Yes, ma'am.
Do you still work there today,
I
son?
sure do.
But it's not the Exxon anymore. What is it now?
It's called Shell Station now.
Shell. All right. On August the 30th of 2022, did the defendant come into the store?
Yes, ma'am.
Okay. And you recognize him sitting here today.
Yes, ma'am.
Judge, if the record would reflect that she has identified the defendant.
All right, the record will so reflect.
And had he ever been in the store before?
A couple of times to buy dip and all that, nothing major.
Had you had any disagreements with him previously?
No, ma'am.
When he came in the store on August the 30th of 2022, what was his demeanor?
Like he just pulled up and he started being irate, or like
Let me back up. Where did he pull up?
in front of the store, in front of the door.
So not at a gas pump.
No, ma'am.
Was he in a parking space?
No, ma'am.
So he parked directly in front of the doors.
Yes, ma'am.
Okay. Did that catch your attention?
Yes, ma'am, it did. Because like I was wondering why would someone pull in front of my door like that?
Did was he driving or was he the passenger?
He was driving.
Were you able to see if anyone else was in the vehicle?
Yes, ma'am.
Did anyone get out of the vehicle with him?
No, ma'am. It was just him.
Was there a long passage of time before he came in, or did he come right in?
He came right in as soon as he pulled in front of the gas station.
Okay. So let's talk about him walking through the doors. Does he come straight up to you, walk around, or something else?
He came up to the counter and started ranting, raving, cussing, and everything else to me.
What types of things was he saying?
That I'm gonna beat your ass. You're the informant for the TBI. You set my girlfriend up. The whole 9 yards.
And have you ever been an informant for law enforcement?
No, ma'am.
How did you respond to his behavior?
Well, to be honest, I got a little bit angry and scared at the same time.
Okay. Tell me, does he stay on the opposite side of the counter from you? Tell me what goes on after this.
Yes, he stayed on the opposite side because I was behind the counter checking customers in. Before he came in, then after the customers left, that's when he came in, started cussing me, calling me names. I'm gonna beat your ass. That I was his girlfriend. Jessica tried to set her up or something like that.
So he thought you were Jessica.
Yes, ma'am.
Now, let me get this timeline a little bit clear, because you said he came right up to the counter, but then you said something about he came up after customers were being checked out. Can you clarify for me?
Because there was one customer in the store before he came in. And after he left, he came up to the counter, and that's when he started ranting, raving, and cussing.
Okay, so you got two he's. So the other customer leaves, and then the defendant comes in.
Yes, ma'am.
Okay. So was anyone in the store when he first came up to you?
No, not at the time, no.
How long do you think he was in the store with you?
Maybe 15, 20 minutes at the max, as far as I can remember.
And were there any other customers that came in during that time?
Yes, ma'am.
Tell me about that.
It was one, then when the customer came in, the situation kind of settled down because he was talking to the other customer, then they both left.
The defendant and the other customer
Yes,
both
ma'am.
left. Okay. When he told you, and are you quoting him when you say, "I'm going to beat your ass"?
Yes, ma'am, I am.
Okay. Were there any other specific threats he made to you?
No, ma'am.
Did he say that one time or more than one time?
More than once, like a couple of times or so.
And when he said that, paired with his behavior, what were you thinking?
What am I going to do? That's when I called 911.
Did you think he might actually attack you?
Yes, ma'am, I did.
Okay. So you called 911, and what did you tell them?
I told them there's an outrageous customer that was threatening to beat me up, cussing me and all that. They needed to come as soon as possible.
So the defendant had already left the store by the time the police arrived.
Yes, ma'am.
Okay. When he left, did you stay in the store or did you attempt to go
I
outside?
attempted to go out, but I went back in because I had a customer come in afterwards.
Why were you attempting to go out?
See which direction he went to, just in case the cops did come, and tell him which way that he went.
Were you able to go outside or did something prevent you?
Something to prevent me was a customer that came in at the time, after everything settled down and he left.
Did Mr. Vaughn do anything preventing you from leaving?
A couple of times he was standing in front of the door, would you let me out? Because I was telling him to leave, you need to leave my store and the whole 9 yards.
Would you have been able to leave with where he was standing?
No, ma'am.
Did you have any reason to believe he was under the influence of anything?
Yes, ma'am, because when he came up to the counter and he smelled like straight up alcohol, because I knew he's been drinking because his eyes was bloodshot red and I did smell the scent of alcohol on him.
Was he slurring at all?
I don't remember.
Was he steady on his feet?
Like I said, I can't recall on that one either.
But you do remember the odor of alcohol in his bloodshot eyes?
Yes, ma'am.
When he had come in previously, had you noticed him being under the influence?
No, ma'am. He was always calm, cool, joking around with me, the other customers.
Now, the store there at Exxon, and this is going to sound like a silly question, okay, is that open to the public?
Yes, ma'am.
The words that he was using when he talked to you, was he using other cuss words, other language?
He was saying F-U, B-I-T-C-H, and that's pretty much it.
Was he talking about the volume we're talking now, or was he louder?
He was a little bit louder. He was outright, just put it that way.
Now, were you able at any point to see the other person in the vehicle?
I seen a glance of her, but I don't remember what she looks like at all.
When you saw her, did you recognize her as someone that you knew?
No, ma'am, I do not. Because I never seen her before.
Did he was screaming at you. Was he also screaming at any of the other customers or just you?
Just me.
When he was screaming, was he standing completely still, moving around?
He was moving around,
What was he doing with his hands and arms?
raising them up, acts like he was going to hit me, or I'm not for sure if he had something in his hand or not.
Now, this was August, so it's summer.
Yes, ma'am.
Okay. What time of day did this happen?
I will say between 5 and 7 because there's still daylight outside.
And what was he wearing a shirt?
As far as I can remember, yes.
Okay. So if he had had a weapon, would you have been able to know?
No, ma'am.
One moment. Have you ever gone by the name Jessica?
No, ma'am, I have not. My name's always been Bethany.
Nothing further, Judge.
Mr. Vaughn, you have the right to cross-examine this witness if you wish to ask questions.
Yes, sir, I do. 1 second.
If you will come to the podium, please.
How are you doing today?
Good, how are you?
All right. You stated that you're familiar with me.
Yes, I am.
Would you state for the record how you were familiar with me?
You were a customer at my gas station. You came in there a couple of times before.
And you stated that what did I normally come in there and do?
You buy a dip or cigarettes or something to drink.
Okay. How long ago did this incident happen between you and I?
3 years ago.
Okay. So your memory of this is all fresh today?
No,
It's not fresh today?
it is because I read the police report and I do remember some of it
Okay, so the police report helped you refresh your memory.
because I actually forgot all about it until they reached out to me
How long ago did they reach out to you?
about a month and a half ago.
Okay, and it brought your memory back? Okay. And how do you feel about that incident?
I just wanted it to go away
You just wanted to go back and you didn't?
because I'm missing work right now.
No, I can understand that. I imagine you are. Is the crystals, is the Exxon connected to anything?
It's connected to crystals.
Is there any way to the crystals?
Yes, there's a door inside of Exxon that you can go through crystals to.
Okay. It's not blocked or anything?
No,
Okay. You stated that when this incident happened with you and I, that there wasn't any other customers in there.
not at the time, no.
When I entered the store, there was none in there?
No,
Okay. And you stated also that I came straight to the counter and started cussing you.
yes, sir, you did.
And then you stated that also that I stayed in the store for about 15 minutes, just walking around afterwards, correct?
As far as I can remember, yes.
You didn't feel the need to grab a cell phone or a telephone and call for help?
Well, at the time, no, but when you started being outright cussing, that's when I did grab my phone and call 911.
And you stated I cussed you when I walked in the store, correct?
Yes, sir.
And then I was walking around the store for 15 minutes.
Yes, sir.
And you called the police while I was still in the store.
I sure did.
Okay. Did the police arrive while was I out in the store?
No,
But I
you
was-
already left the property.
I was in the store for about 15 minutes. How long would you say that you talked to the police before I left the store?
About, as far as I can remember, about 5 or 10 minutes after you was in the store, that's when I called.
About 5 or 10 minutes. Okay. Have you ever been arrested before?
We're going to need a jury out.
Ladies and gentlemen, if you'll step across the way. I would remind you not to discuss this case with each other until you come back in and the case is concluded.
Your Honor, I have a mind at this moment to ask for a mistrial. The defendant was advised before court that there was no history to be asked about. He can't ask about arrest. He can ask about convictions, but she doesn't have any that are admissible. This is an attempt to sway the jury with inadmissible information.
Your Honor, I had no intent on doing that. You stated that I could ask certain questions surrounding that or her convictions. I mean, I can reword it for you.
You don't need to. You've already asked the question that was impermissible. The question that you could ask was, have you been convicted of a felony or a crime involving moral turpitude or dishonesty? That was instructed to you this morning. You even asked me to define what was a crime of dishonesty. You were, having been instructed what the two questions you could ask were, you asked one that was not permitted. So the options I have are to bring the jury back and instruct the jurors that you were specifically advised and instructed by the court not to ask that question, that it was impermissible. Or I can grant the state's motion for a mistrial if that's what they choose to do, and we'll have to grant a mistrial. And it would not be creating for you double jeopardy, because a mistrial that results from the defendant's own misconduct is not a bar to a future prosecution. It would just mean that this case gets rolled to January, and we come back to it then.
Why January?
Because I'm not here again until January.
Can another judge sit in? We're under a speedy trial still.
They can, but I've heard all the motions that you have filed, and therefore I would be the one.
I don't think anybody can do any different.
Pardon?
I don't think anybody can do any different.
I tend to agree with you. General Bryson, do you wish to have a mistrial, or do you want me to instruct the jury?
Judge, I will not ask for a mistrial at this point. If there are any other inadmissible questions, I will return to this issue. I would ask that the jury be instructed.
I will. Bring the jury back. Mr. Vaughn, please make sure that you do not ask any inadmissible questions. If you have a question that you want to ask that you think might be inadmissible, then you need to ask it outside of the jury's presence. We'll have a jury out hearing.
Well, why they out? I got a question for you then. You should have said something.
Stop them for a moment. What do you have?
My next question I was going to ask, was she on drugs?
Oh.
Oh,
That would not be admissible.
okay.
I mean, Judge,
I don't
if
think
he's
that violates the
attacking,
rules.
hold on. If he's attacking her ability to perceive, remember, I think he can ask, was she under the influence of drugs at that
You're
time?
talking about at the time of this occasion?
Of course.
Yes. I don't think he can ask, during the time frame, have you ever used drugs? Did you use drugs? I think it is permissible to ask at the time that this happened in the store.
Right.
Answer present, correct?
You can ask the question, was she under the influence of any drugs or controlled substances at the time that this incident occurred 3 years ago?
Okay.
All right.
Well,
Bring the jury in.
he wants to make her discredit her, make her look like a bad person. Just wants to impeach her with issues that are not. You're not allowed to impeach someone like this. You're not allowed to ask someone who's never been arrested of, child essay. Have you ever been arrested of child essay? Because you're just making the jury think they're a bad person just because you're asking the question. And this is just a lay witness who was allegedly accosted by this guy.
All right, thank you, ladies and gentlemen, for your patience. I'm going to instruct you about something. There are rules of evidence or rules of procedure that I've told you about that I have to enforce.
Oh, yeah.
Prior to the beginning of this case, there were certain issues that were raised, and Mr. Vaughn is representing himself, but nonetheless, he was instructed that there were certain questions that were not permissible. He just asked a question that was not permissible, and I had sustained the state's objection. I told you before in my instructions that the questions themselves are not evidence. So the fact that he asked a question that was impermissible should not raise any inference, nor should it create in your mind any question about this witness's character in any way, shape, form, or fashion. The question that was asked was impermissible. It had been ruled on earlier, and therefore I'm instructing you to disregard the question and not to attach any significance or not to try to infer what the answer might have been had he been permitted to ask that question. And I've instructed Mr. Vaughn to avoid asking any such questions in the future. Mr. Vaughn, do you have any other questions?
Yes, I do. Have you ever been arrested for any felonies?
No,
At the time of this incident, were you on drugs?
I was not, no.
You were not on drugs. You stated that I was a customer at this store previously. You've seen me multiple times before, correct?
Yes, sir.
Did I always park in the same spot when I came to this store?
No,
She know.
Okay. Did I buy anything from you when I entered that store?
no. As far as I can remember, no.
After I allegedly said these things to you, I just chose to wander around the store?
Yeah, you was close to the front door walking around and you left when I called the cops. And that's when the other customer came in and y'all both left.
Okay. You said that I was speaking to another customer in the store? Mm-hmm. Okay, and was we loud or laughing?
No, you was talking normal to him.
I was talking normal to him. Did you feel any fear at the time? Or
I
threat?
did, that's why I called 911 for.
So you felt fearful. Did you ask me to leave the store at that time?
I sure did, and you kept on saying, no, I asked you numerous times to leave my store, and you never did.
And this is why I was talking to the other customer too? Did the other customer say anything?
As far as I can remember, no.
They didn't intervene or? Did you just say that I also was acting normal at this time, speaking to that customer?
You was, yeah. Because
Okay,
you wasn't outright, you wasn't cussing, you wasn't yelling or anything like that.
so me telling you, no, I'm not leaving your store is an irate and,
No, because your demeanor was different when you was talking to me and the customer. Your demeanor was different.
what would you say? I'm like a normal person?
The way you was talking to the customers, like me and you talking now.
Okay. Would you say that I was under the influence of something?
Yes,
What do you believe I was under the influence of?
alcohol.
Dude!
You stated earlier to the state that you tried to leave the store but was prevented by a customer because you had to go check them out.
Are you the state's second chair?
Is that like normal fear tactics or something to go check out a customer?
Yes, because the way your demeanor was, I was making sure you left my property and see which direction you went to so I can tell the officer when they showed up.
What right direction did I go?
You went the right towards Events Auto Park.
I believe earlier you stated to the state that you didn't know which direction I went because you went back in the store to check out a customer.
Exactly, but when the customer left, I walked outside and seen what direction you went to.
Okay. Was you still in fear?
When you left, no.
Okay. When I was in the store, did you say anything else to me besides get out the store?
As far as I can remember, no.
Okay. You were behind the counter when I came in the store, correct?
Yes.
When did you come from behind the counter?
When, I really don't recall that one when I did.
Was I still in the store when you came from behind the counter?
Yes.
What was your purpose from coming from behind the counter?
Trying to get you to leave my store.
So you were gonna physically make me leave?
No.
Please.
I was trying to get you to walk towards the door so you can leave.
And how were you gonna do that? Please explain.
There's no way to explain it. I was walking towards you. I wasn't going to hit you or anything. I just wanted you to leave my store.
And you were scared doing that?
Yeah, I was.
Okay. You stated earlier also that I prevented you from leaving the store. Can you please explain in your own words?
You was standing in front of my the store door, so I couldn't walk out.
Is this also where the vehicle was parked?
Yes, in front of my doors,
Was I inside the store or outside the store?
out the store.
Inside the store. Okay. And Crystal's door was still open?
No, it was not because it was locked.
It was locked? Is it always locked?
No, but when I'm there, most of the time, it is locked.
Why is it locked at 5 p.m.? You told the state earlier it was about 5 p.m. this incident happened.
Yes, like I just said, most of the time when I'm working, I keep that door locked.
Oh, you keep it locked?
Yes,
So you can unlock this door when you want to?
I sure can.
Oh, okay. Okay, so if you needed to leave the store that way, you could if you needed to, correct? Okay.
Oh, they let the
So did you
woman
feel like
out.
you were trapped?
Please.
Not at the time, no.
Okay, thank you. No more questions.
Redirect.
I rest my case.
One moment, Judge. No redirect, Your Honor.
All right, thank you, ma'am. You may step down, and is she released from her subpoena?
Judge, I would ask that she remain under the rule.
All right, if you will step outside and remain under the rule in case you need to be called again. State may call your next witness.
State would call Corporal Jeffrey Clark. Goes by Scott.
God.
Clark, step around, raise your right hand, be placed under.
I was trying to remember when I called your name.
It's okay.
Would you spell your first name and your last name for our court reporter?
My first name is Jefffery, and my last name is Clark.
Corporal Clark, were you working on August the 30th of 2022?
Yes, ma'am.
And how were you employed at that time?
I was a patrol officer for the City of Dixon Police Department.
And how long have you been in law enforcement?
Going on 5 years.
So you would have been about 2 years in at that point?
I believe so, yes.
And has all of that time been with the City of Dixon?
Yes, ma'am.
Corporal Clark, did you receive a call out to the Exxon on that day, April the 30th?
Yes, ma'am.
Not April, August the 30th? Were you the first officer on scene?
No, I was not.
What officers arrived before you?
2 agents with the 23rd Judicial Drug Task Force.
Is it normal for the drug task force to respond to calls in the city?
If they're close to one that has come out, especially a priority one, which is calls that require lights and sirens, if they're close to it, they will respond until the other city cars get there.
And did dispatch categorize this as a category or a priority one?
To my knowledge, yes.
Do you know about how long they got there before you?
I do not an exact time frame.
Would it have been minutes?
A couple minutes, yes.
When you arrived, tell us where all of these different parties are.
When I arrived on scene, the 2 agents with the drug task force were already out with Mr. Vaughn and his girlfriend at Advanced Auto Parts.
And Advanced Auto Parts is, where is that located connected to or relative to the Exxon?
Right next door.
Do they share a parking lot?
Actually, let me rephrase that. I believe Dixon County Tire and Oil, I think, is in between them.
Okay, so it's some distance over.
One business over.
Would the defendant have had to get back on the main road to go over, or can he traverse through parking lots?
I believe you'd have to go out and into another parking lot.
Who did you speak to first?
I spoke to the agents on scene,
And then who did you speak to next?
Mr. Vaughn.
And what statements did Mr. Vaughn make to you about what happened?
He advised that he got into a disagreement with the female inside the store.
Did he elaborate on that disagreement?
Said that there was some argument going on between the female in the store and his girlfriend.
And did he make any statements about his actions in the store?
And other than that, no.
Did he tell you anything about leaving the store and holding the doors?
I believe he said something about holding the door.
What was his explanation for that?
Off the top of my head, I do not know.
But he did make an admission to you to hold the door.
Yes, ma'am.
Would you have put in your report why he told you he held the door?
I don't believe he gave me an exact reason.
Okay. Who did you speak to next?
I believe I went over and, well, actually, I spoke to Miss Dozier at that time, but she was very hesitant to tell me anything of what happened.
Let me ask you this. When you went up to speak to the defendant, what was his overall demeanor?
Pretty upset.
Were you able to get his name from him?
At first, no,
Did you ask him who he was?
we did.
And once or more than once?
How many times, I do not recall.
Did you ask his girlfriend who he was?
We did.
Would she give you his name?
No.
Were you ultimately able to identify him as Sherrick Marquis Vaughn?
Yes, ma'am.
Okay. And that's the same person that's seated here at council table?
Yes, ma'am.
Get a statement from him. Ms. Dozier, would she talk to you at all or just didn't want to say
Didn't
anything?
really want to say anything.
Next, who did you talk to?
After that, I went and spoke to Bethany.
Were you able to view any of the surveillance footage from the store?
The full-on video, no, but she showed me a still shot after she described her sequence of events. And a still shot showed Mr. Vaughn with his hands up in the air. And in my report, I remember notating that there was a customer in there when he had his hands in the air.
Now,
You just
let's
don't
talk
care.
about body cameras for a second. You normally wear a body camera,
Every shift.
and you also have an in-car video.
Yes, ma'am.
When you brought this case to the DA's office, did you bring copies of those body cameras?
On the old software, they are downloaded onto DVD disc, and they should have been with that grand jury packet, yes.
And do you download those or a supervisor?
The supervisor does.
Okay, so you didn't bring DVDs with this packet, is that right?
To my recollection, I'm not sure.
Okay. Would you remember marking the grand jury packet sheet?
I remember marking DVD request submitted, and I remember submitting that to my sergeant.
Okay. So what does that mean?
That with the old body camera footage, the body cameras are required to be docked via USB cord into the docking system. After
So you have
that,
to physically take it off and plug it into the
yes,
computer?
ma'am. We did that every shift. After that, the car camera videos are downloaded onto an SD card that are inside the dash camera. Those are taken out and swapped with an empty SD card every 2 weeks when we do our time cards and pay periods. Those are also provided to the sergeant, and those get downloaded into the software.
With all those moving parts, is that the same body camera and car camera system that the police department uses now?
No, ma'am.
Hold on one sec, guys.
About when did that transition take place from the old system to the new system?
2023, I believe.
Why did the police department change body camera systems?
Our digital ally system was having problems with corrupting files and losing the camera footage.
Did you intentionally destroy or have anyone else destroy the body camera?
No, ma'am.
So there is no body camera available today.
No, ma'am.
We don't know if it was human error or computer error.
Do not know, no.
Why did you charge the defendant with false imprisonment?
Due to Miss Bethany's statement about him holding the door shut and preventing her from exiting the store, taking away her liberties of escaping the store.
It's a little weak.
So by false imprisonment, you don't mean that he tied her up.
No,
You mean he prevented her from having a clear path to exit.
correct.
The defendant, as you spoke to him, did you smell the odor of alcohol on him?
I did.
You did?
Yes, ma'am.
Okay, are we talking a little bit, a lot? Could you elaborate?
To my knowledge, I don't know how much. I do know that the odor of alcoholic beverage was present on his person.
Why did you charge him with disorderly conduct?
With Miss Bethany's statements, along with the person being there in the picture of the still shot of the camera footage, causing a public alarm.
Did he ever hit Bethany Page?
No, ma'am.
Why did you charge simple assault?
He, according to Miss Bethany's statements, with him threatening to beat her up, the opportunity and jeopardy was there at the time. And she said she was placed in fear.
Judge, at this point in time, I'll pass the witness.
Vaughn, you may cross-examine.
Yeah, so far that charge is very weak.
Afternoon, Mr. Vaughn.
Can you recall how long ago this incident was?
3 years ago.
Okay, 3 years ago. Was it summertime, wintertime?
The technical term, I believe, still summer,
Still summer.
with it being August.
You seem like you got a very vivid memory of what happened. Would you please explain to me how?
My police report.
Your police report. Okay. You stated also that there was an issue, there was errors with your body cams possibly, correct?
Correct.
Okay. Was there also some issues with your patrol cam?
It was all in one software. The issue wasn't with the cameras themselves. The issue is with the software at the department.
Okay. Was there any issues with the Exxon cameras?
We did not have Axon cameras at the time.
No, I'm talking about, I know
Oh, the
you
Exxon.
didn't.
Oh, I'm sorry. Our new body cameras are called Axon, so I thought that's what you said.
Okay, that's nice.
You were
to know.
saying the Exxon gas station.
Yes, sir.
Not to my knowledge.
Did you happen to get a copy of these pictures?
I did not.
May I ask why?
I believe I wasn't able to get a copy at the time.
Was there anybody else present at the scene?
It's a
when
good
you got
point,
there?
Brad.
At which scene? The Exxon or the
Let's say
outside
witnesses
of the
per se. Any witnesses per se?
witnesses, i.e., are you talking other law enforcement officers or are you talking just citizens?
Citizens or for anybody? Just
Off the top of my head, no.
okay. So you weren't the first to arrive at the scene, were you?
No, sir.
So all the information that you received is from DTF or Miss Bethany, correct?
Correct.
Not firsthand knowledge?
No, sir.
Okay. You stated that you charged me with a public alarm. This was because of a picture you seen?
Disorderly conduct.
Oh, disorderly conduct. This was because of a picture you seen?
It's based off of Miss Bethany's statements along with her sequence of events. And then that picture she showed me with the customer being in that picture is why I charged you with that.
So
Causing a
hand-
public alarm.
And how would you describe how it looked in the picture?
Off the top of my head, I cannot. I know in my report it notates your hands were up in the air.
Does that technically mean like I was being aggressive, violent, threatening, public alarm? Does that mean that?
It would coincide with the mannerisms of someone who's in upset attitude, but I cannot say for sure.
How would you say my attitude was when you encountered me?
I don't think you were happy dealing with law enforcement.
Okay. After hearing Miss Bethany's statements today, would you say they're about the same as they was the day you arrested me?
Not all the way, but it has been 3 years.
Okay. When you were speaking to Miss Bethany, would you believe that she was in fear?
I did.
You did. Did you notice any other doors inside the Exxon?
I was not paying attention.
Okay. And when you encountered me, where was I at?
The advanced auto parts store.
Would you say, how long would it take you to get to the scene?
From
From where you were? Well, I don't know when you received the call, but how long would you technically take to get to the
a
scene?
couple minutes.
Couple minutes. So it wouldn't take you 10 minutes?
No, sir.
Okay. What about DTF? You think it took them about 10 minutes?
I do not believe so. I know they were nearby. Their exact location I'm unaware of.
They got there before you too?
Correct. I do remember being down south, and if you're not familiar, down south is our southern jurisdiction area of our city is towards like the interstate. I was not all the way at the interstate, but I was in that zone.
Okay. So you say, what is your typical response time if someone made a call?
A
About
couple minutes.
couple minutes, being 2-3 minutes?
Couple minutes.
Okay.
Unless it pops up right next to me.
Did you hear that I was driving irate or anything?
Not driving. No.
You trying to get away from a scene or something? Seemed like I was running from anything?
Nope.
You think if I was running from something, I would go to Advance Auto Parts next door? Okay.
Good question.
There was no other witnesses on the scene?
Not to my knowledge.
None to take witness statements from?
Well, not to my knowledge, but at the same time, if a witness doesn't want to provide a statement, they don't want to be there and cooperate. They don't have to.
But if your body cam was on, that would corroborate with that, correct?
Correct.
Okay. What about Miss Bethany? Did she make a witness statement that night?
She did not.
Okay. What about the DTF? Did they make a supplement witness statement?
They did not.
Okay. You said you felt like Miss Bethany was in fear. What is your normal procedure with dealing with somebody that's in fear of another person?
Would you elaborate?
How would you comfort the situation, or how would you address the situation if I told you I was in fear of this person right here? How would you address that?
I'd ask you how they made you in fear.
Okay. I told you I was just scared, and you come to the conclusion that it was an assault you want to charge the person with. What would you do then?
Well, in that situation, if we're going to talk about that, If she's saying she's in fear in a public setting when there's other people around, that constitutes a public alarm mixed with the opportunity and jeopardy being there with you saying, I'm going to beat your quote ass, then that would constitute an assault because it occurred.
Okay. So did you hear me make these statements?
No,
You got any proof of these statements?
Miss Bethany.
That's your only proof?
Yes, sir.
You believe her to be very truthful?
That is her testimony. She swore to it.
Okay. Do you believe it to be truthful?
I do.
Okay. So what is, someone that tells
Could've
you that they're
objected
scared,
there.
what do you do after you arrest someone? What's your normal procedure? Do you have a victim statement you give them? Do you notify them that they can put a restraining order on someone? Or, do you just let them go on about their lolly-dolly way? You don't have to make a statement. or
Dolly,
nothing?
Dolly,
For
wait.
domestic violence is yes, but not just simple assaults. No,
Someone that says they're in fear, wouldn't you make a record of that other than just arresting a person?
that's what the police report's for.
Lolly,
Just so she
Dolly,
don't need to make
way.
a statement?
She don't want to.
Did she want to, or did you not give her that
I
option?
cannot recall.
Okay.
I do like him.
Have you ever been inside the Exxon?
A couple times. Not a
Dolly,
lot.
Dolly.
Is there another way into the Exxon besides the front door?
I'm not sure, honestly. I don't frequent that store a lot, so
Okay. You're not for sure if there's a door into Crystal's between them?
not to my knowledge, I'm not sure.
Okay.
No offense to her, but kind of not a good gas station, so I stay away from
I
it.
agree. Okay, let me see.
He's done some dumb things, but he's also asked some good questions.
So
Hit
everything
miss.
that you're basically telling me you put in your report was not firsthand knowledge you received from other officers that was on the scene prior to you. You stated that you didn't think I was too irate when you got there, did you?
You were not happy, I will say that, and you were not acting normal.
What's that mean? Would you use your own words?
Upset, I would say. You weren't talking like this.
Okay. Was I screaming, ranting, raving?
You're a little louder, yes.
Was I screaming?
Off the top of my head, I can't remember, but I remember it wasn't like this.
Was I ranting and raving?
I can't remember.
Was I free?
Free.
Well, was I in handcuffs?
At one point, you ultimately were put in handcuffs, yes.
And where was I placed?
Later on in the back of my patrol vehicle.
All right, thank you. No more questions.
General Bryson, redirect.
Let's clear up a few things. When you got to the scene, were there any other customers in the store?
Off the top of my head, I'm not sure, but I do remember that picture of the security camera footage. There was a customer standing there with them.
If there had been customers in the store, would you normally have spoken to them?
Yes, I would have.
So if your report doesn't indicate you talking to any customers, is it most likely that there were no customers at the store?
Very well could be.
In fact, usually if there are people on scene, you take down their information.
Correct.
So if we look at your report, you would have down the defendant's information, his girlfriend's information, Miss Page's information. Would it help refresh your recollection to see if there are any other information you took down that night?
It would.
Take a look at the document that I have handed you, and when you are done looking at it, let me know, pass it back up, and I'll ask my question again.
Okay.
Okay, will you pass that back? Did you notate that there were any other customers on scene when you arrived?
No.
Let's see, you were asked if you had any firsthand knowledge. Let's clarify that. You had statements from the defendant, right? And Miss Page, and then you also looked at the still photos from the surveillance. Would you say the still photos aligned with what Miss Page said or contradicted it?
I would say they align with it.
Okay. And then we've been throwing around the term witness statement. Miss Page did not write you a written witness
No,
statement,
ma'am.
right?
No, ma'am.
But she talked to you.
Correct.
Would you say she talked to you freely?
Correct.
Did she answer any questions that you had?
I would believe so, yes.
Okay. So she did give you a statement. She just didn't write one down.
Correct.
And the same, you spoke to the officers that were on scene, the drug task force officers.
Correct.
Okay. Even made notes in your report about what they told you.
Correct.
So they didn't write a statement, but they still gave a statement. Would you say that's correct? All right. Nothing further, Judge.
Anything else, Mr. Vaughn?
Mm, so, you stated that there was no other witnesses at the scene, correct?
Off the top of my head, I do not know. However, there is none notated in my narrative or in the witnesses tab of my report.
Okay. I'm still just mind boggled about the fact that,
Judge, objection. Let's keep to questions and not statements.
she didn't let me ask the question.
Well, you were making a statement. What is your question?
I'm still mind boggled about the fact that you were at the scene and you didn't have nobody write a statement. How is that possible?
At the time, I had a body camera on as well.
The body cam that didn't work,
At the time, it was working, yes.
but
Everyone.
earlier you stated it was error, so it was
Later
working.
on, I can't predict the future, so.
Okay. That'll be all, Your Honor.
Anything else from this officer?
Future.
Are you
Hi.
mind boggled? Hi.
I'm
Do you believe
mind-boggled.
that your body camera was recording the event?
How are you, Hella?
I just let myself in and change the layout because it's better this way.
I like it.
Yeah, I can do that. Okay, so I have to ask a question because I may have missed something, but it seems to me there's no fucking evidence against this person.
So far it's pretty weak.
There's no fucking evidence against this person.
The witness themselves kind of discredited the whole the charges of the witness not being able to leave or like holding them captive. And what?
What? Yeah, tell me. What am I missed?
Oh,
Where's the evidence against
yeah,
this
and she was able to leave. She had a key. She could go out the back. So you weren't holding her against her will. Yeah, it's a very weak case.
There's nothing.
And that's a petty charge too.
So okay, like, what are the actual charges? There's holding someone captive. Is that it?
Yeah, there's like 4 or 5 charges. Let me keep playing and I'll try to see if I can get them.
Okay. I don't want to interrupt for too long, but
Yeah.
yeah,
That night.
please,
Yes.
because I think this is bullshit,
And
mate.
had you not had a body camera or not known that it was having issues or whatever, would you have handled the situation differently?
Correct.
Yes, ma'am, I'm sorry. Had you not been wearing a body camera or had you known that we would have issues having a copy of the recording, would you have handled the situation differently?
Yes, ma'am.
How would you have handled the situation differently?
In that term, I would have first, if it was a problem with the body camera while on scene, they had a visible red light illuminated whenever they're on and recording. If it had been dead or non-functioning at the time of the scene, I would have went into my car and swapped the battery in it to see if that fixed the problem and make sure it was recording at the time. If I knew I didn't have a body camera or if I knew it was going to mess up, I probably would have went the extra route of writing statements, yes.
So you had a means on the body camera to see that it was working while it was recording.
Correct.
So it recorded that night. We just don't have the recording.
Correct.
Nothing further, Jen.
Mr. Vaughn, anything?
Okay.
For the culture.
This should be
I
the
don't
right
like to
one.
think this is because he's blick.
No, I don't
to think that's what it is.
I don't
but,
think
I mean,
that's it. I think they're just dicks in general.
Yeah, I mean,
Um,
I've seen like shitty cases against white people too, but I mean, this is a shitty case. It seems. Please tell us.
Yeah.
Hang on. Should we go like this for now?
Yeah,
Or
sure.
something?
So we got 4 charges: assault, threat, or a threat of bodily injury. So that's the gas station or the woman saying, "Oh, I'll beat your ass" or something like that.
Mm.
False imprisonment, which it sounds like it's bullshit. Disorderly conduct,
Is that
and
throwing
public,
your hands in the air?
yeah, and public intoxication.
Well, they don't know about that because they have no BAC.
Yeah, so it's just, oh, I smelled alcohol, but you don't know if they were really drunk or not.
So you can throw out the BAC. Looks like you can throw out the what is
Yeah.
it?
False imprisonment.
False imprisonment. This threat of bodily injury. Someone did just testify to that, right?
Yeah, the woman did that. I'll beat your ass.
Yeah, so there's that one's maybe,
Maybe, yeah.
but that's just one person. That's
But
all we
then
got, really.
they're getting yeah, it kind of bugs me. They're getting really petty with the false imprisonment. And when they start getting really petty, I start getting sus on the other charges.
This disorderly conduct. So how many people have they got to testify to these things?
The clerk and like 2 officers so far.
From what I've seen, the officers can't remember shit.
None of them can, yeah. Yeah, it was like
So
3 years ago.
So the actual victim.
And the victim said she didn't remember it either until she was called to testify and looked at the police report and didn't want to be there.
God, I wish this guy had a lawyer.
And his girlfriend is going to testify for him again.
This is crap.
Yeah.
I'm so mad. All right, I can go back.
Okay. Oops, which one was it?
Thing.
Yes.
Is this the right one?
You stated you would have handled it different if you known your body cam wasn't working.
Correct.
What is the relevance to that? Like, would it have changed the fact that you didn't get a witness statement for everybody at the scene, including your fellow officers?
Well, like I said before, if a non-officer civilian witness does not want to write a statement, I can't force them to. I can ask, but if they don't want to, I can't force them to. The fellow officers with the drug task force I work with and alongside, so I can just get their statement from them personally. And if need be, if I wanted them to write a supplement, I could ask them.
You didn't feel the need to get them to write a supplement for you when you weren't the first person on the scene?
No, sir.
Wouldn't it be more adequate to do it?
At the time, no, because I had my camera footage.
Let me ask you this. You stated that you also
What
felt
camera
like I was
footage?
under the influence of drugs, correct? Or alcohol, or whatever the case may be.
Alcohol, yes.
Okay. Did you give me a field sobriety test?
Their body cams
Did you
malfunction.
get my blood drawn that night or anything?
No.
Did you give me a breathalyzer test?
City of Dixon doesn't use breathalyzers.
So there is nothing that you can possibly prevent to this, show the court today that I was drunk or under the influence of anything. Is there?
My testimony that you had the odor of an alcoholic beverage emitting from your person on that afternoon mixed with
I mean, in their defense, I think they just got a DVD player in 2023, so breathalyzer.
That's no defense.
Yeah,
It's fucking stupid.
they were still using 8 tracks until 2010.
So his answer is my testimony that you smelled of an alcoholic beverage. Well,
Yeah.
someone can smell an alcoholic beverage after one.
Yeah.
Doesn't mean that you're over the limit or impaired. I mean,
Yeah.
you might have been.
I mean, I haven't had alcohol in 10 months. I'm sure I still reek of it.
You probably
So-
do. Your whole house does.
Yeah.
I can smell it from here.
I know. I'm a
And
drunk.
I'm in Australia.
But yeah, it's, or, he could have spilled a beer on his pants and wore the same pair of pants the next day.
Look, it's possible he was drunk, but this
Yeah.
is not good enough.
It's not, beyond a reasonable doubt.
He's a cop. Come on.
Yeah.
Come on.
Well, although if you're yelling at the cashier of a gas station,
Maddie, I thought you were off the alcohol, mate. Come on now. Come on.
my training and experience.
So your training and experience, I mean, you could just speculate?
If you can smell the odor of alcoholic beverage emitting from someone's person, it's usually due to them consuming it.
Okay. Was there anybody else at that scene tonight with me, maybe?
Your girlfriend.
Okay. Was she under the influence of anything?
I do not recall.
What about Miss Bethany that night? Do you know if she was under the influence of anything?
Not to my knowledge.
beyond.
Okay.
Good. Hugs.
That's all I have, Your Honor.
All right. Thank you, officer. You may step down.
Thank you.
General Bryson, you may call your next witness.
It's the state's approved, Judge.
State has rested their proof. Ladies and gentlemen, if you'll step across the way.
You rested
to the
on
jury
that?
room,
Did
and
he
let me take
say-
up a matter and then we'll come back to this.
Rested their poof.
They're proof.
I thought they didn't like poofs in Tennessee.
They don't. That's why they didn't bring that one officer back to testify.
He stacked.
Yeah. He was kicked out of the courthouse, actually.
Respond, the state has rested their proof, and as you know.
He wanted to get
petition
married, and they were like,
on a couple of occasions,
no.
It now falls to you to decide whether or not you want to testify at this trial. Do you wish to testify today? You have the right to call witnesses, and I know you have a witness here. Do you want to call your witness
Is that a Confederate flag
and
he
offer
has?
her a testimony?
Yes, Your Honor, but I also have a question too.
Oh, God.
I know this is a state's, whatever you want to call him, but at the same time, he's a witness in this. For him to be present a full time, wouldn't that be kind of unfair on my behalf?
I'm sorry, what?
I mean, he's a state's witness, and he's also, what do y'all call him else? He got 2 titles today. The state's
Bitch.
designee or whatever. I mean, wouldn't that be unfair to the defense to have him sitting through the whole proceedings and giving testimonies after hearing other witnesses?
Well, okay. First of all, you should have objected before now.
It's a bit late.
That's a valid question, but there is an exception for the officer to assist the prosecutor. It's a good point, but it
Yeah.
should have been raised earlier. For
Yeah, I mean, they've
clarification.
rested their case, for God's sake.
Yeah,
I
it's a
mean,
little late for that, but
yeah.
I do understand your confusion and why.
Yeah, and
would-
it's happened all the time. I mean,
Yeah.
the lead detective or whoever
Yeah,
the hell it
always
is usually
sits there
sits
to
through the
help.
whole thing.
And quite frankly, I do understand his point, but
It's fair.
it should be sequestered, in my opinion. But they're not.
Well,
It's
it may
almost
be
like this
considered to
happens
be
in every
unfair to
case.
you, but it is the rule that allows the state's designation of a law enforcement officer in a criminal case to be seated at a table and to be present during that. They're exempted from the rule. A specific a specific provision of the rule allows the state to designate a law enforcement representative, and that person can remain in the courtroom. So whether it's fair or unfair in your opinion, it is permitted by the laws. Now, the next question is, do you want to
Whether
put your
it's fair or
witness on the
unfair,
stand
tough
and then
case.
decide whether or not you want to testify, or do you know at this point where you want to testify?
Supper.
Let's put the witness on the stand.
All right, we're going to take about a 10-minute recess, and then we'll come back and let the
This
jury
might be
know
over
we're on
fairly
recess
quick.
for 10 minutes, please.
So that was a no?
He's gonna put his girlfriend on the stand.
So that was a no. He's not going to testify, right?
Well, he's gonna put the witness on the stand.
So I'll decide later. Was that his answer?
Well, he's gonna put a witness on the stand.
Hello.
Hi. Oh,
Hi, Jen.
ugh. Hate Jennifer's. Good
She looks
Lord.
like a skank.
She looks like she was born in. Yeah, they all are. She looks like she was born in Mesa. I'm not bitter or anything, though. Oh, Judge.
Vaughn, you may ask.
Africa.
How are you doing?
Okay.
Okay. For the courts, would you tell them how you know me?
You are
How
the
you
father of my
doing?
kids. We've been together on and off for 20 years.
Okay, are we together now?
Not currently, no.
How long have we
Aw.
been separated this time?
A little over a year.
Okay. You mad at me or something?
No.
The reason I'm asking do you have a reason to be vengeful, or you want to
I-
answer truthfully here today?
Truthfully, I just didn't agree with. We didn't see eye to eye on things.
That's irrelevant.
Do you still love
We didn't
me?
agree with our lifestyles.
Okay. Okay.
Oh,
you recall-
baby.
Oh my God, I love this guy. He put his ex on the stand just to be like, do you still love me?
Are you mad at me? Can we get together
You know,
later?
you're under oath. You have to answer truthfully.
Oh, baby, can we get together later and have a
Oh.
little bit of a horizontal dancey?
That's the kind of passive aggressive shit I do.
what we stopped at the Exxon for that night?
Candidate.
Did I get that can of dip?
No, you did not. That was most expensive
Aw.
candidate.
And what?
I didn't get the can of dip.
No, you didn't.
Dip.
Oh, darn. Have you been inside the Exxon before?
Yes.
How many doors are there in the Exxon?
There is a door directly in the front of the Exxon, and then a door that conjoins with the crystals, and they actually have a door in the front as well.
Okay, so there's multiple entrances and exits into the Exxon.
Yes.
She's got
Okay,
multiple
um,
exits and entries.
Did you witness anyone
More whores, I bet.
threatening anyone that night?
Well, no, I didn't witness the threatening.
Did you?
Man, put the microphone right up against your mouth there and
Whoa, Judge.
speak loudly, please.
Put the
Careful.
microphone right up
Did you witness
against your
anyone
mouth.
threatening anyone that night?
No, I did not.
Okay. Did you witness anyone being hit?
No, I did not.
Okay. Didn't you witness anyone else present at the scene when we were at the Exxon?
No, there wasn't a lot of people at the Exxon.
Not a lot of witnesses. Okay. When we left the Exxon,
That doesn't
did we
sound
leave
good.
in a hurry or?
No.
Okay. Where did we park at the Exxon when we was there?
Seems like you parked right in front of the store.
Hey, Jeremy.
Is this my normal place to park?
Yeah. Everywhere.
What do you mean by everywhere?
Oh, come on.
For the courts, please.
You just, yeah, you don't like parking and having a walk, so you park right on the store, like right at the store every time.
There.
Okay.
His legs are painted
So
on.
when we left the Exxon, was it any? We weren't running from anything, were we?
No.
Bailiff needs to just
Where
shove
did we
it
go
down
when we
our
left the
throat.
Exxon?
2 businesses down to the Advanced Auto Park.
Right. The microphone.
Would you believe that I was irate that night when I was driving away from Exxon?
No, I think you're actually kind of laughing a little bit.
Okay. What did we do when we got to Advanced Auto
We
Parts?
went in and got a car part for our boss's derby car.
Okay. How would you say my attitude was then?
Fine.
Freaking white
Did you see
people.
my attitude change at any time during that night? Okay. When did we have a altercation, or let's say not altercation, but the word I'm looking for? When did we make first contact with the officers?
The officers at Advanced Auto, after we were already in the store getting the part.
Okay, so we didn't run into the officers basically until we exited the store.
Yes.
Okay. Do you know a Miss Bethany Page?
No, I do not.
How often would you say that I went to Exxon?
Not often. It wasn't a regular store.
Okay. Would you state what side of the town our regular store would be?
Pomona,
Pomona. Why would that be our regular store?
because that's where we lived
Okay.
for 20 years almost.
Okay.
20 years.
And you don't know Bethany Page?
I do not.
She don't know you?
Not to my knowledge.
Would you be able to pick her out if you've seen her?
Absolutely not.
Do you believe, to the best of your knowledge, that I know a Miss Bethany Page?
Not to my knowledge, no.
That I'd be able to pick her out if I ever seen her?
Not that I'm aware of.
Okay. Let me see. Any more questions for you?
I don't know who Alicia Andrew is, guys.
Did I exit the store with anybody? Did you see anybody at the store?
No, I mean, she came out right after you.
She came out of the
She
store?
did come out after you, yes.
Did you see her body language or anything?
It seems like she was kind of yelling a little bit, and you kind of laughed at it.
Okay.
Well,
Do you feel like she was scared?
no.
Oh.
Okay. Did you see her with a phone or anything in her hand?
No, I wasn't looking really at her hands.
How long would you say that the time lapsed from the time we was at the Exxon to Advanced Auto Parts?
A couple minutes, if that.
Okay. Would you believe that someone that wants to harm somebody would go next door to Advanced Auto Parts?
It doesn't seem very smart.
Do you believe that my actions that night were to do anything to get a part? But get a part for a derby car?
No.
Okay. I think that's all my questions I have, Your Honor.
All right, General Bryson, you may cross-examine the witness.
Kind of. Oh, she needs to cross her. So he did something.
Did you get out of the store at the Exxon? Or
No,
did you
ma'am.
get out of the car at the Exxon?
No, ma'am, I was in the car,
Okay. What were you doing in the car?
just waiting.
Scrolling your phone?
No, just waiting, just sitting there, you know.
Were you paying extra attention to what was going on in the store?
Whenever I seen him come out and then her come out, that's when I noticed, like, hey, you know, and then she said she was scared. Why would you follow him out of the store if you're that scared? I'm going to call the police. I'm not going to
So
go
you,
out.
you didn't look, you didn't pay any attention until they both came out of the store.
She followed him out of the store.
And you would call the police if you were scared.
Yes, absolutely.
So
I would
she
go out
could have
with him and
just
be like,
run away.
"Lock the door, lock it."
Okay. Did you
Well, that's new.
observe if any other customers came in and out?
Not to my knowledge, no. I didn't
Okay.
see it.
Wow.
Were you staring out the front window, watching
Well,
traffic?
he parked kind of like facing the auto parts store, like straight in front of the store with the front towards Crystals. So when he come
Okay.
out, I seen that because I was in the passenger seat.
So when he pulled up to the store, you're in the passenger seat. Was the passenger seat beside the gas station or the driver's seat beside the gas
The
station?
passenger seat,
And I say gas station,
the front
not the
door.
pumps, but
Yes,
the
ma'am.
building.
It was mine.
She seems pretty certain.
Have you ever heard Mr. Vaughn yell?
I'm with him on and off 20 years. I've heard him yell.
He can get pretty loud.
He
Wait,
can, you know,
how old is this
take him.
woman?
Okay. Nothing further, Judge.
30s.
Can you
She
redirect?
looks 20.
I know.
at
But they've known
most.
each other for 20 years.
You stated that you were in the vehicle,
I was,
and the vehicle was pointed towards Advanced Auto Parts Crystal's direction, correct?
yes,
Would you say your door, the passenger door of the vehicle, would you say it was directly in front of the Exxon door?
pretty close.
All right, here's a real good question for you. So why did I go to the Exxon?
Pretty up.
And I went into the Exxon. How long would you say that I was in there?
Couple minutes.
Did you see which direction I went when I went to Exxon?
And went around the back of the vehicle.
No, I'm talking about when I entered the store.
I don't remember that part. I'm sorry.
Okay, you couldn't see the counter?
No, I wasn't paying attention to the counter, to be honest. I mean, you don't pull up the store and expect, you know.
Would you say I was in the store just 10 minutes, maybe?
No, it wasn't even 10 minutes.
15 minutes?
No, maybe 5 to 7 minutes.
Did I exit the store with anything?
I don't remember. I don't think you did.
Okay, let's see. That's all, Your Honor.
Ms. Ross?
I don't know.
You knew that the defendant went into the store to get dip
Yes.
and that he came out of the store without dip.
Yeah, 5 minutes to 15 minutes is literally one of the witnesses in My Cousin Vinny, who's like, I saw him go in and it was less than 5 minutes and they were out and just shooting off. And then you find out that the witness was cooking grits during that time frame. It would have had to been like at least 15 to 20 minutes. I'm just saying like that. Yeah, the time matters.
I find she's a really interesting witness because, like, they're not together at the moment, right?
No.
He established at the beginning that she's not mad at him, but they're not together,
Yeah.
right? But he is the father of her children, and they were together for a really long time. So the jury's going to kind of see her as maybe being sympathetic to him, but
It's
like,
weird.
she's
Yeah.
going to have some bias,
Yeah.
right?
She's coming off a lot better than the last time I saw her testify.
Definitely, right? She
She was a
definitely
wreck the
seemed
last time.
she didn't seem too good last time, but she seemed very sure about the
Yeah.
things that happened. She's not getting rattled by the prosecution at all. She seems like she's the most sure of anybody,
Yeah.
including
Yeah.
like by a long way. So if she weren't connected to the defendant, I'd be more inclined to believe her than anybody else.
Yeah.
It's just that she's connected to the defendant. That's all.
Well, I seen him coming out and her coming out behind. Because at that point, I kind of heard a little bit. And I was like, doing over there, you know. So
What'd you hear?
I don't remember. This has been years ago. I just heard her screaming and he was kind of chuckling and coming around the bar. I don't remember what was said.
Did you ask why he didn't buy dip?
Yeah, and we had discussed it. And
What did he tell you?
he got into an argument because Miss Bethany thought that she knew me and apparently wanted to fight me. So he was trying to stop her from coming out to have an altercation with me.
Okay. Nothing further, Judge. Did you know Bethany?
I did not. It was a very bad case of misidentification.
Did you think you knew her that night?
I thought I knew her from school and from younger days.
What did you think her name was?
Jessica,
Nothing further, Judge.
Also a whore name. Just kidding.
Only believe her about what she says, not about
Yeah.
the things she's
The state seems
speculating
to
about. Regardless,
want to have the court believe that I went to the Exxon for a Jessica.
Leading.
Would you say that I went to?
Let me
No
rule on
objection.
the objection. Sustain the objection.
Oh,
You're
hang on,
making a
wait.
statement rather than a question.
Let me rephrase it for you. Did I go to the Exxon looking for a Jessica?
No, you did not.
Do I know a Jessica?
Your cousin's wife, but I don't think that one matters.
That works at the Exxon, I could say.
Not to my knowledge.
So I went to the Exxon for what?
Dip, strictly dip.
Did I go looking for trouble?
No,
Do I know anybody that works at the Exxon?
no.
Did I give any indication that I wanted to go to the Exxon for trouble?
No.
Asked and answered.
You stated that she followed me out the store.
Yes, you did.
What would you think the reason for her following me out the store would be?
Anger?
Sustained.
Speculation, but
You said, what was she doing out the store?
You're saying, are you asking what actions she was doing
Yeah,
outside?
yeah.
I mean, I just seemed like the yelling and the hand motions.
Okay. No police showed up at this time?
Not at the store, no.
Was the police called at this time that you're not?
No, they were not.
Okay.
this is the defendant,
that's all I have, Your Honor.
Jeremy.
Yeah, I'm glad you didn't notice that it was
Bryson, you have three calls.
pro se defendant.
Yeah.
Thank you, ma'am. You may sit down. Mr. Vaughn, you may call your next witness. Ladies and gentlemen, step across the way just for a moment, please.
Okay.
Conduct what we call the Momon hearing as to whether or not you wish to testify.
No bond.
Can I ask a question about that, Your Honor?
You can ask a question about it, yes.
How do I testify at the trial for myself? Do I write questions down and give them to you, or
No,
I just?
you just take the stand and then you testify, you state, you're placed under oath, and then you say what you want the jury to hear as far as your version of these events, and then the state has the right to cross-examine you.
Okay.
No, beautiful. Sorry,
I'll
love.
testify, Your Honor.
You will.
I'll
All
testify.
right. Then we're ready to bring the jury in.
No way.
You
Jury,
told me that he
the state filed a notice of impeachment before trial. It was filed in March of 2023. A copy was given to Mr. Flanagan and Ms. Coffinberry, who were attorneys for the defendant at that time. The same was provided to the defendant when he was mailed discovery.
I don't know if
I would
it
ask
was.
for the court's ruling on which of those convictions will be admissible to ask him about.
But what day did you file that?
March 23rd, 2023.
You have a copy that you can provide to the court without me having to look through.
I do.
Yeah, beautiful. But this one's innocent.
Mr. Vaughn, the state has filed a notice of impeachment and range of punishment as they are permitted to do under the law that states that if you were to testify, they are asking that they be allowed to introduce the following for impeachment purposes: that you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 114 of aggravated assault, a Class C felony, and received a sentence of 3 years on November the 18th of 2016. Second, that you were found guilty in Circuit Court in docket number 2015 CR 134 of evading arrest, a Class E felony, and received a sentence of 2 years. And that was November 18th of 2016. That you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 199 of aggravated robbery, Class B felony, and received a sentence of 8 years, November the 18th of 2016. That you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 200 of aggravated robbery of Class B felony, and received a sentence of 8 years, November the 18th of 2016. You were found guilty in the Circuit Court of Dixon County, Tennessee, docket number 2010 CR 706 of aggravated assault.
Why should they be able to bring
Class
this
C
in?
felony, and received a sentence of 3 years on
Impeachment.
July the 15th,
But why? It's
2011.
bad acts prior.
And
Why should they
finally,
be able
that you were
to?
found guilty in the
Because
Circuit
he
Court of
would
Chino
testify.
County on docket number 16001 of failure to appear, Class C
So?
felony, and received a sentence of 2 years on April the 27th, 2010.
A lot of times there's stuff they can bring in to impeach him on cross, including prior bad acts.
Only if he opens the door to it.
No, not when it comes to convictions for defendants.
Just
It's a
because he gets up
credibility
on the
issue.
stand.
Yeah.
Just because he gets up on the stand,
Yes.
they can bring in prior.
Yes. They can limit it, or they can there are certain things they can bring up because someone testifies that they would not be able to bring in otherwise.
I'm not sure about this. I don't know if I trust
Hey,
Dolly.
CH.
Hey!
This is a pro se defendant out of Tennessee. He's definitely got a past, and he's currently in jail. He's had a trial before that he was found guilty of. I forget for what. I mean, it wasn't anything major. It was a traffic violation or something.
This dude's reading out all the things he's been found guilty for.
Oh, well, I mean, one that we watched.
Oh.
But he's got a past.
Yeah.
But right now he's on trial for threatening assault, false imprisonment, disorderly conduct, and public intoxication. But basically the sheriffs from Mayberry investigated this, and they don't have breathalyzers. The witness that said she was imprisoned was seen chasing the defendant out of the gas station. It's pretty weak.
It's incredibly weak.
Those are the offenses that the state intends
Bit of a
to
record.
cross-examine you about and bring that out, because it is permissible to cross-examine someone on a charge, rather who is testifying, by showing that they have felony convictions. I'll be glad
Every
to hear
state.
you if you want to argue against
Think
the
so.
introduction of those.
Yes, Your Honor. The relevance to this case, they have no relevance. I didn't harm anyone. There's nobody physically harmed.
Clearly
As you
that's
can see,
a rule.
all them
Okay,
cases
no
are very
problem.
violent. There was people actually touched in those cases. This is just some he said, she said. That's not the case here. I mean,
He said, she said, bullshit.
you know what? Forget all that. How about this? I don't testify. I ain't got more time for this. Let's finish this. I ain't gonna keep going back and forth with
okay.
y'all. This is crazy.
The law permits the state to impeach a witness by the introduction, or anyone to impeach a witness by the
Yeah,
introduction of
good.
felony convictions.
Good point.
So long as those convictions are not related specifically to the type of case that we have here. Having explained to you what the state's intents are, now you have decided, if I understand correctly, and you state under oath that you desire not to testify. Am I correct?
I would
Yeah, ain't
too.
no point in it. It's a monkey show, bro. Straight kangaroo court in here.
Hey! Don't be dissing kangaroos.
Vaughn, I have treated you with, let me have another phone, please.
I liked you.
I've treated you with as much respect as I can do for it, as I would any other criminal defendant, even though you're representing yourself. You can make that kind of insulting statement.
What
all
did
you
he
want
say?
to, it will not change self-respect.
Let me go back.
Hey.
I missed it.
Hey,
Desire
Hey,
not to
hey,
testify. Am I
Judge.
correct?
Yeah, ain't no point in it. It's a monkey show, bro. Straight kangaroo court in here.
now you got me offside.
It's not an Australian court, sir.
Hey, shut up. Right?
Vaughn, I have treated you with, let me have another phone, please. I've treated you with as much respect as I can do for it, as I would any other criminal defendant, even though you're representing yourself. You can make that kind of insulting statement all you want to. It will not change the outcome of this court, nor will it affect this court's ruling on matters that are between, or that are within my. Let me have one more. I'm gonna have to quit talking.
Look, I'll do to you what I did to the gem yesterday.
And Mr. Vaughn, this is that waiver of your right to testify. You've been given your right.
He's that way. Do you think you've got a bit of hurt feelings, Judge? What don't you? Judge is a bit upset. It's sad. It's sad. You got called a monkey show?
Is that squiggle line your signature? Is that the only signature you ever use?
You can use it.
I can use it. I don't care if I.
I know you can. You just use the signature I gave you.
Let the record reflect that the defendant has handed to the court.
Someone's
waiver of
got
the
a
right to
tood.
testify, and that he executed that in this courtroom on the 23rd day of October, 2025. And that the signature line appears to be just a squiggly line. It does not bear the same signature as he has on the many multiple motions that he has filed. But I will accept this as his signature and his waiver of his right to testify.
He got the shits and he wouldn't sign it.
love
just
this
went,
guy.
All right. Then we're
Got
ready to bring the
spunk.
jury back.
Oh, that's amazing.
fuck this monkey show.
So just vodka in there.
And now he's acting like, oh, give him a break. Hey, I don't blame him. Well,
Yeah.
he should
General
he
Bryson,
should have a bit more
I'm
decorum in
about to
court.
have
Could
the
you pause it for a
Final
second?
charge printed,
I don't want to talk over him.
and you've got that.
Be all, Your
Okay.
Honor.
Dali, could you pause it first?
Hmm.
Please. Yeah. He should have more decorum in court. However, he didn't realize, and I didn't either, that just because you get up to testify, that means that everything you've ever done can be brought in to impeach your credibility.
Every conviction.
Yeah.
Like
Can be
you
brought
can't
in.
bring in arrests, or like if he's in
Oh,
jail
yeah,
on a
fair.
pending charge, you can't bring that in. But
Fair. But prior
conviction,
bad acts, right? So prior bad acts can suddenly be brought in because you get up on the stand.
now usually it's, have you been convicted of, or how many times have you been convicted of a crime? And you say, I've never been convicted of a crime, when it's been 3 times. Well, then you just open the door to going into each and every single time. But if you're just like, I've been convicted 3 times, then that's usually it. Maybe they would be able to go like, have you been convicted of this?
Yes.
I guess that depends on the state.
I would think
But-
if it was something that was relevant to the actual case, then fair. But if it's something completely irrelevant, I don't see why you would be able to bring that in. So so the law seems to be that it's just to undermine your credibility as a witness, right? And you are the defendant and therefore a witness. Just that blows my mind. So okay, the person gives up their Fifth Amendment right, which is a big deal.
Yeah.
And suddenly anything that they've done that they have been convicted for, even if it's completely irrelevant to the case and a distraction, can come in.
There are
and-
like ways to punish you if you testify.
Exactly, right? And it's already very risky.
Yeah.
Right? So he didn't know that. He said, sure, I'll testify. And then the judge says that not just was the judge that said it, or was it the prosecutor that said it?
Prosecutor brought it up.
Yep. He realizes this and he's like, no, I'm not. No. And he smartly realizes that that's going to be very bad in front of the jury.
Yeah.
And he chucks a little mental, which is not a great idea, but he did chuck. He's smart to have said no.
Yeah.
At that point, I think.
He did. He should have had this information, Kay. Yeah.
He should have had the information prior. Yeah.
He should have known, but who knows?
Anyway.
He's preparing for his other trials.
No, that'd be all, Your Honor.
All right, state having rebuttal proof?
No, Judge.
Then-
Come back in for closing arguments.
All right, she may be allowed to resume.
You think prior arrest should
Resume
always
courtroom.
come in? No, not arrest.
You were called in to hear the charges against the defendant of simple assault, false imprisonment, public intoxication, and disorderly conduct. The state presented to you direct evidence, which is the judge gave you in your first jury charge, is proof of a fact such as the testimony of an eyewitness. And you heard that proof from Bethany Page.
Contradiction.
This incident was so significant in Miss Page's life and in her work that she called 911 from the store there. She didn't call the non-emergency number. She didn't call her boss. She called 911 because she was afraid of what would happen. She told you that between the defendant shouting, his waving his arms, his pulling his hands back as if he might hit her, his actual statement that he was going to beat her up, that she was afraid. That is charged under Tennessee law as a simple assault. So to give you a bit of a legal background, once upon a time, assault and battery were 2 separate offenses in the state of Tennessee. Assault being the fear that someone would hit you, and battery being someone actually hitting you. Tennessee has charged that under one statute, which is simple assault. And the state is proceeding under the theory that she was threatened, that she felt threatened. She felt like she could be hit. She felt like she was in danger of imminent bodily injury. So if someone is to call over the phone and say, I'm going to hit you, there is no imminence. They can't do it immediately. Mr. Vaughn was across the counter from Bethany Page when he told her he was going to beat her. And he made drawbacks as if he might. It was during that time customers came in back and forth. He would calm down and then ramp back up, continuing to yell at Miss Page, continuing to call her names, continuing to make a scene in the store. And I need that other. Let's talk about the disorderly conduct. So the court is going to read you the law on that. And one element, the first element, is that the defendant was in a public place. The Exxon is a place that is open to the public. Now, why this is charged in addition to the simple assault is because the effect of the behavior on the public around. When you commit an assault in the public, it can qualify also as that disorderly conduct. So the defendant was in a public place with intent to cause public alarm or public annoyance, and he engaged in fighting or violent or threatening behavior. And he acted either intentionally, knowingly, or recklessly. Those are the elements that you have to find the disorderly conduct charge. Okay? So we presented proof that while in a public place, the defendant was not only saying he was going to hit Ms. Page, he was acting as though he was going to hit Ms. Page. Now, as for the public intox, witnesses testified that they could smell the odor of an alcoholic beverage on him, and Ms. Page testified specifically that she remembered seeing his bloodshot eyes. Public intox, it is not a crime to smell like alcohol in a public place. You combine that with the rest of his behavior, that the defendant was under the influence to a degree that either the defendant may have been endangered, he may have been endangering others, other people or property, or that he unreasonably annoyed people in the vicinity. And again, that he was in a public place, acting either intentionally, knowingly, or recklessly. Now, the false imprisonment sounds like he would have had to tie Ms. Page up. It is enough that he blocked her path to the exit. There is some testimony that there was another door to the building, that the door was locked. This would be, this would require the victim to jump through hoops, that she would get the key, that she would go unlock the door, that she would take the other path. Where here you have the victim saying that she was trying to see where he was leaving, where he was going, and he was blocking her path to exit. You also have that while she was behind the counter, he kept coming up, blocking her path to exit. She was trapped in that space behind the counter. So you have more than enough proof to find there. You have testimony from the officers indicating that he was still, kind of upset when they got there, even though he had relocated to a different store, didn't like interacting with the officers, didn't want to identify himself, generally just being disagreeable, which is a carryover from his behavior with Ms. Page. This is not a homicide case. This is not an aggravated assault case where a weapon was used. But this was still a significant day in the life of Bethany Page, to where she picked up the phone and called 911 because she was...
A significant day? She said she didn't even remember it.
No. She didn't remember it. Neither did the cops. None of them did.
You can't say she felt threatened and was terrified, unless she's getting threatened every single day.
Yeah, must have. Yeah. Oh, you mean, which day was this? I call the cops every week.
Yeah.
Works in it's a petrol station, right?
Yeah.
Gas station?
Yeah.
That's what it is. It's on?
Yeah.
What do you expect?
In fear for her safety. And you are faced to look at the charges that were put before you and decide if the proof today meets those elements. And if you think that they meet those elements, then I would ask you to return a guilty verdict on all 4 charges. Thank you.
Mr. Vaughn, you wish to address the jury?
Yes.
Let's go. Let's go, bros. Do better than your opening, please.
How y'all doing?
How you doing,
Y'all
Matt?
heard the evidence from the state. You heard evidence from my behalf. Them sound like 2 different stories if you can hear what I'm hearing here today. State is making statements that the woman was blocked behind the counter. I never heard that here today. I've heard that she freely walked me out the door. I also heard the woman state that I was in the store for 10, 15 minutes talking to other people. Doesn't seem like someone too scared right there. Also heard that she made a statement of calling 911. It doesn't take 911 10 or 15 minutes to get to Exxon. It's in the middle of town. DTF showed up. Dixon PD
really
showed up.
couldn't
Wasn't
give
even
a
at the
shit.
scene. Excuse me, I have a piece of paper I want to read you out.
Aw. Look at brother counsel there.
He's doing a good job.
Much better than last time.
Let's talk about the false imprisonment. You've
talk
heard
about
that the witness state that I blocked her path outside the store where my truck is parked. I don't see that really blocking a path if I'm already parked in front of a store. You also heard the witness say that she locked the door to the other side, and she never did state that she didn't have keys to open that door. I had to go get them. If someone's in a store for a while, I don't see any way possible for someone to be harmed. If they wanted to harm them, they can possibly harm them. Let's talk about the public intox. You can blame red eyes on anything. There's no proof that the state can provide, Ms. Bethany, nor the testifying
Demonhood.
officer, that there was any public intox. There was no breathalyzer test. There was no field sobriety test. There was no blood drawn, no nothing that they can provide other than their statements here today.
That's true.
Let's talk about this public alarm. This is a TCA statute. It's 40-7-103. Grounds for arrest by an officer without a warrant. An officer may, without a warrant, arrest a person for a public offense committed or a
You don't
breach
need
of
a
the
warrant
peace
to arrest
threatened
someone.
in the officer's presence. I've proved here today that nobody was present. There was not an officer present. There was just me and Miss Bethany in the store. It's virtually my word versus hers. She has no witnesses on her side to back her statement. I have no witnesses on the side to back mine. It's he said, she said, like I told y'all from the beginning.
Bullshit.
Wasn't that CCTV?
I went all the way to Advance Auto Parts store.
I don't believe
If I really wanted to harm someone, I believe that was in my well means to do so. Standing in the store for 15 minutes, parked in front of the store for however long that was, and not even a rock throw away at the Advance Auto Parts next door. There is no public alarm when the officers didn't witness it. There is no public intox when you have no proof to provide that there was intox. There is no false imprisonment standing outside of a door. There is no assault when I'm standing in a store talking to someone, as the victim themselves stated I was, and then freely of my own will leave the store. And it's the fact that the memories of everybody,
yeah,
from the
Brett,
officers
thank
to all the witnesses here today, they're very vague. 3 years is a long enough time for anybody. To actually believe that these charges I should be found guilty of, I believe there's enough evidence to believe that I shouldn't. And I want to thank y'all. Have a good day.
God bless.
I want that to happen
Bill
so
Bryson, you have
bad.
the final say.
It is not guilty. It should be not guilty.
I'll waive rebuttal clause, Judge.
Oof.
All right, ladies and gentlemen, then it's time for me to charge you and give you your final say.
All right. So just the jury instructions now. Prosecutor should
Please.
come up and be like,
Everything that guy just says bullshit.
all right, we're going to get to the verdict, guys. So
Let's
Judge
do
Reed,
it.
they deliberated for about half hour.
No. Earlier it was just a hearing, David.
Yeah, earlier was the hearing.
If you want accurate information, you've got to stick around.
To bring the
Oh, what are you doing under there, Judge?
defendant out,
Why does
please.
hang on, can I ask you something before this? Has he been incarcerated for 3 years?
Yeah, he's in there for some serious stuff.
Okay.
So, I mean, the defendant is just having fun. Like all his charges, he's going to be in there for a long time. So he's just
Okay.
like, he gets to play lawyer.
Okay, so this
It's
is the
kinda
nothing. Like this particular case is just like a little blip on the radar of his criminal.
Yeah. But
Right.
he's having fun, I think, playing lawyer, defending himself, which I'm not going to fault him for. If I was in his
That's
position,
fair.
I'd do the same.
That's fair. That's fair. Because I mean, really, if he were held in jail for this shit for 3
Yeah,
years,
no, that'd be
that would be
outrageous.
bullshit.
Yeah.
Yeah.
No, he's in there for some serious shit. I forget,
Right.
like
Okay.
robbery and
Okay.
Bring them back. I was handed, after the jury had been charged and had retired to deliberate, I was handed a motion to dismiss that Mr. Vaughn has filed. And for the record, I will state what the motion says. I, Sherrick M. Vaughn, come before the courts affirming the foregoing to be true, and to the best of my knowledge, paragraph 1, I move to dismiss this case for the witnesses, both the officer and Bethany Page, watching the entire processings and verified it. The fairness in having witnesses prepped while my witnesses are without help to remember is prejudice against the defense. Number 2, the state did not give proper notice of their witnesses in chief until a week before trial. Number 3, a false arrest against the Fourth Amendment is Tennessee statute. The officer did not witness any of this, so no public alarm or threat between Advanced Auto Parts store and the Exxon. 4, none of the witnesses' testimony are fresh and believable. My prayer is for the courts to uphold the Constitution and admit this is illegal and dismiss with prejudice. Mr. Vaughn, do you have anything else that you wish to add to that argument other than what's been stated?
Nothing I can prove, Your Honor.
All right. State wish to make any sort of response to this motion?
Yes, Judge. First of all, the officer, as we've stated, was designated as the state's designee to be seated at the table throughout the proceedings. Ms. Page was not in the courtroom at any time other than her own testimony and the closing argument, which was after the close of proof. We have previously discussed, and you have ruled on the state's proper notice. Both witnesses that testify, names were clearly listed in discovery, Ms. Page being the victim and the officer that testified being the author of the report. I'm not entirely sure what number 3 is. Number 4 is a question of fact for the jury.
I am treating this as a motion for judgment of acquittal since it was filed after the close of the state's proof. Whether I treat it as a motion to dismiss or a motion for judgment of acquittal, since we're at the trial stage, I will deal with each of his issues that he has raised. And number 1, he moves to dismiss for the witnesses, officer and Bethany Page, watching the entire proceedings. And I found, as I have already dealt with the officer being the designated legal representative of law enforcement, that the rule does not apply to that individual. And for that reason, Officer Clark would be allowed to remain in the courtroom. Number 2, there's no evidence whatsoever that Bethany Page watched the trial proceedings. The only evidence was that she may have watched part of this morning's motion hearing, which are 2 completely different proceedings, and therefore the rule was not imposed upon her because she was not a witness. So issue number 1 is denied. 2, ruled on it this morning, therefore this motion number 2 is denied. Number 3, a false arrest against the Fourth Amendment. And we have also dealt with that same issue.
Yeah, blah, 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 denied.
And therefore I deny the motion.
Did you make a rule on that?
should have done this. You should have done this at the end of the
Says, please don't
prosecution.
dismiss Jennifer to preserve statement
Right.
for a violation in another
End
case.
of
Yeah.
I don't know what that
Why
means.
did
I didn't have time.
Well, he didn't know.
Also, not just that, it shouldn't have just been about like who was in the courtroom. It should have been the fact that there was no freaking evidence,
Yeah.
right? Right? That's usually why there's a motion to dismiss at the end of the state's case.
Yeah.
Yeah. Dude, there's no
Because I
point
was
putting
trying
this
to
to the jury.
Yeah.
Focus on this, but it was a motion. I need to file a motion to preserve testimony for a violation she witnessed herself in the last case we had here, Your Honor.
Well, I have no authority to hold her, for any reason. So, you can file something and have a hearing set and subpoena her. But as far as me holding someone, she's not under arrest and she's under a subpoena, but that concludes at the end of this trial. So for that reason, your request to hold her to preserve a statement is not something that
Was she dismissed already, Your Honor?
I don't know whether she's gone or not. So. But your request for this court to order that she be held there's no legal basis for doing so.
Denied. Anyway.
Been able to reach a verdict, is that correct?
Okay, so jury's coming.
Ladies and gentlemen, I'm told that you have been able to reach a verdict, is that correct? All right, are you the foreman? All right, let me go over this form with you and we'll go over this together. As to count 1 of the indictment in the charge of assault, how does the jury find the defendant? Guilty or not guilty? Not guilty. As to the charge, count 2 of the indictment, the charge of false imprisonment, how does the jury find the defendant not guilty or guilty? as to count
What
3
was that?
of the indictment on the charge of false imprisonment.
No.
I'm sorry, that was a false imprisonment. As to count 3, the charge of disorderly conduct, how does the jury find guilty or not guilty? And as to not guilty. And as to count 4, charge of public intoxication, how does you find guilty or not guilty? So all 4 counts, the jury is unanimous in its finding not guilty. All right, then thank you for your time, and you are ready to go until 6 o'clock Monday night when you need to check that number to determine whether or not we need you for the trials on Tuesday. Thank you.
Based.
I wish I could tell you don't have to come back.
He won.
He insults the judge.
All right, Mr. Vaughn, the jury has found you not guilty of these 4 counts.
God damn it.
So far.
That leaves us with 2 other charges. I think that 2 other indictments that still need to be dealt with.
I did, Judge. You were so pissed. You wanted to fry. Not that he would fry,
So he
but
has a
you know what
driving
I
on
mean.
revoked license, third offense that he withdrew his guilty
Yeah.
plea on, and we need to set that for a trial. Do you have an idea of when you want to try that, General?
Oh, and like some of the other charges he pled guilty to use them in front of the jury. Be like, hey, I accept a responsibility for this, just not this stuff. And then after the trial, he withdrew his guilty plea and wants to go to trial on that now.
Really?
That was at the last trial.
The prosecutor just lost to an improper homie
Who's in jail?
who's in jail. That's just gotta hurt.
Oh, it needs to. That's humiliating.
So humiliating.
And
Oh,
and she came this close to asking for a mistrial
just
because the
like-
defendant was asked the witness if she'd ever been arrested.
Just imagine going to the Christmas party after that.
Yeah, imagine going back to the office tonight.
Oh,
Oh, she's going to get a DUI on the way home.
imagine.
Well, I know there was no evidence, but
She shouldn't
She
have
bought
taken
it.
it to freaking trial then, should she? These people need to learn a lesson from the shits.
they,
Good
yeah,
on you, jurors. I wish the jurors would come out and talk.
I know that is so based.
They need flowers. They need a slab of beer. Little stuffed kangaroos and monkeys.
Wow, for the kangaroo, so much for a kangaroo
Yeah.
court, buddy. Not that much of a kangaroo court now, is it?
Stop it. Stop with the kangaroo court thing. I don't know where that term
Let me go
came
ahead and get my
from.
other ballot.
It's crap.
Australia.
No.
Oh,
I'm going to go ahead and on 2021 CR 462, that is
Resign.
the case with the aggravated assaults, reckless endangerment, and felon in possession of a weapon. State is going to enter a nollie on that after discussion with the victims. That will leave.
We're gonna we won't we'll drop the charge for the other stuff. Oh,
Just like that. Didn't have to go think about that, did ya?
she just got wrecked.
Remember in Warren County, they had to go talk to the DA about it.
Yeah.
I have to go to talk to the DA about it. Might take some
Yeah.
time.
Yeah.
This one's like, oh, we'll just drop it.
Yeah,
Yeah.
she at least has some sense.
Yeah.
Give us one
Uh,
case to set.
doesn't anything more to do with it.
I would like,
And that is the driving on a revoked license, correct?
yes,
Right.
I would like, I've not had a chance to talk to one of the THP representatives about his driving history. Could we set well, you have to give us a date. Or could we set it in front of Judge Wallace for him to,
Oh, I'm sure Mr. Vaughn would probably prefer to have a different judge anyways.
No, I like fighting with you.
no, I'm not saying for Judge Wallace to take the trial because you already said the first half of it. But could you give me a little bit to make a decision on whether the state's going to go?
Oh, I like fighting with you.
Stick with you, thanks.
You're my lucky judge.
I've already felted you, so I'll just keep felting you further.
Oh, this is amazing.
I'm sure you don't want me. Such a face.
If anybody noticed, my mouth went wide earlier, like an hour ago. I
Yeah.
was looking ahead.
Get the DUI guy face.
Yeah, embarrassing. But I heard that earlier and I was like, holy shit. Wow.
Forward or let that one go as well.
Your Honor, would that be new witness evidence she's providing? She's talking about she need to get a hold of THP?
Nope, you have a copy of it.
And now he doesn't even know what he's doing. He's just bumbling. Oh, is this new evidence? You have a copy of it.
She is so passive aggressive right now. You have a copy of it.
So every time he makes a legal mistake, it just rubs more salt in her wound.
Uh-huh. This is great.
It's just a person I need to talk to clarify something.
All right. So what are you asking to do about that? We've nollied the one case that you have a victim problem with, and now we're down to the driving on a revoked license third offense. What are you wanting to do about scheduling? You wanting to put it on a date for Judge Wallace to consider setting a date?
I tell you what, Judge, could we, I know you're back for the Godwin case. Would you want to pick a date that morning before trial or?
As far as I'm concerned, you're talking about on Tuesday, the 28th?
No, I'm talking about November the 6th. I have Cordarius Godwin.
Oh, I forgot.
Yes, you scheduled that.
Cordarius Godwin is set on the 6th of November. I don't have a problem with it. 8:30 in the morning, we'll consider whether we'll have Mr. Vaughn here, and we'll meet.
What'd you say, November 26th?
November the 6th.
November 6th at
Let's
8:30
see if
a.m.
I'm
We'll
free.
have a hearing, a status
Get
hearing.
my lawyer calendar out here.
Yeah.
What you're planning
Let
to
me
do, and we'll
see.
set a trial date at that point.
You know what, Your Honor? Do I need to put
Busy
in a
that day.
motion to, never mind, Your Honor, never mind.
No, I don't need to put in a motion to dismiss judgment notwithstanding verdict
Right.
now, do I?
Then we stand adjourned.
Because they said not guilty.
They did.
He was so prepared to put in that motion to set aside the verdict. Oh, I guess I don't have to do that.
I don't need to.
I
do
won.
that now,
Huh.
do I? Funny. So what are they talking about? What's his next hearing about?
There's one other charge that they haven't decided if they're going to dismiss yet because they need to talk with the victim, I guess.
He'd be feeling a little bit confident.
Yeah. She just got felted, so.
I'm so happy for him.
I
This is
know.
brilliant. Imagine him going back to his cellies and that.
Oh, God, yeah. He is going to
Imagine.
be just top bunk.
He is. He's just gonna. He's gonna get celebrated. There's gonna be noodles and Kool-Aid and honey buns.
Oh, yeah. Premium
Wow.
Pruno
Premium.
from February of 24.
Oh dear.
Oh, that's amazing.
Yeah, I would not add anything you want to do. Yeah, that was great. Good find.
Yes. Yeah, I've been looking forward to the next one, and this did not disappoint.
Yeah. Oh well, I had a
s-
meeting and I was like, nah, I can probably wait for half an hour.
There you go. Thank you. I'm glad you joined.
I'm glad I did too. That was worth it. He's the
sure.
Alan Jackson of Cell Block 6.
Yeah.
He needs to work on his opening.
He does.
He does.
Yeah, he was found guilty in the last one, but no, he did good this one.
Was he a pro se then too?
Yeah.
Right.
So he still had the nerves then, but kind of worked through the butterflies.
Fair enough. Fair enough.
So, all right, guys.
Thanks for hanging out, everyone.
It's been a lot of
Yeah.
fun.
No stream today. I have work to do. I've been too busy in the Lauren rabbit hole. That sounds terrible. All week. I need to give it a rest for a day.
One day
Guys,
off.
if you find out anything interesting, let me know, but I might not be able to look at it for a few hours.
Yeah. All right, guys. I'll see you tomorrow at 10 a.m. Eastern.
Okay.
Bye.
Cool.